Is that what you asked for?
I'm going to use a short period of time, and whatever time I need for rebuttal.
Okay.
25 minutes is a long time.
Yeah, well, you use what you want. Okay. Staff, can you please identify what items are already part of the record?
Yes, thank you, Chair. The record includes the contents of the staff report and its attachments, the public documents found in both the violation file and permit file for this matter, the addendum, which was both distributed to you and also posted on our website last night, and today's hearing itself.
All right, and how much time would you like for your
25 minutes, please.
25 minutes, okay. There should not be any ex partes on this, but do I have any? Nope. Very good. All right. So I'll review the rules for the proceedings. Staff has asked for the 25 minutes, so I'll give the alleged violator the same amount of time, and we will allow 3 minutes for any other party who would like to speak as an interested member of the public. Anyone who speaks at this hearing may propose questions, either orally or in writing, that they would like commissioners to ask of any other party. But it is not appropriate to propose questions to be asked of yourself. Commissioners may choose to ask the proposed questions at their discretion, but are not required to do so. Okay. So we'll begin the public hearing with our staff presentation.
Thank you very much. The violations at issue here arise from the unpermitted demolition of affordable motel rooms that provided accommodations for coastal visitors and the related unpermitted construction of a high-end hotel and the failure to provide low-cost accommodations in that hotel. Before we get into the details of the enforcement action, I wanted to step back for a moment and point out that this case illustrates the complexity of providing coastal access to all visitors and the breadth and significance of your efforts to ensure that there are opportunities for coastal access for everyone. We heard a little bit about this morning, about access being more than just blocked gates. Gates that block easements, security guards that work to privatize beaches at the behest of local residents, signages that purport to limit public parking or access are the more common examples of the violations that you see and address in the access area. But what of the lack of the accommodations that people who aren't in the highest tax bracket can still afford? Many people, especially those coming from our inland areas, need affordable motel rooms, hotel rooms, campsites, and the like in order to bring their families to enjoy a stay at the coast. The lack of affordable accommodation is a significant obstacle to these visitors and their families. The scarcity of accommodation is primarily a significant planning issue that the Commission and staff work on, but in the matter before you today, that scarcity has been compounded by the unpermitted demolition of low-cost motels and the construction of a luxury hotel in its place. Fortunately, working with the hotel developer, we have reached an agreement that we think will, amongst other things, provide a great opportunity to construct much-needed new affordable accommodations. We're pleased to tell you that the hotel developer and operator, Sunshine Enterprises, has worked with staff to reach a cooperative resolution of the violations. We've reached a proposed matter through the proposed consent, cease, and desist order and consent administrative civil penalty before you for your consideration today. We will collectively refer to these two proposed Commission actions today as the consent agreement. Although the order does not require Sunshine Enterprises to tear down the hotel, we are directly addressing the violation in the enforcement action, and one of the requirements of the consent agreement is for Sunshine Enterprises to obtain a coastal development permit for the hotel, which would in turn address the impacts of the project, or, failing that, to cease operations. Therefore, in order to be efficient, we've coordinated between permit and enforcement staff, and one of the next items on the agenda today is the coastal development permit application for the Shore Hotel. But please note that, if approved by the Commission, the obligations of the consent agreement are binding on Sunshine Enterprises regardless of whether a CDP is approved for the hotel, and nothing in the consent agreement is intended to affect the Commission's discretion in reviewing that CDP application. In addition, our bringing this order to you today is part of our ongoing effort to, when possible, resolve violations at sites first, as the Commission has repeatedly indicated is their preference, and which can be, when possible, more efficient for all parties. In addition, Sunshine Enterprises has agreed to pay a substantial fine to resolve its liabilities under the Coastal Act. And we'll discuss this further, but we envision the use of these funds to greatly improve opportunities for affordable accommodation and public access in the area. We're very excited about what could be accomplished with the funds to be paid pursuant to the consent agreement. We greatly appreciate the cooperation and participation of Sunshine Enterprises and their representatives in crafting this proposed resolution and recommend that you issue the proposed consent agreement to resolve these violations. Today's presentation will be given by Andrew Willis, the Southern California Enforcement Supervisor and Acting Deputy Chief Counsel. Alex Helprin is also standing by to answer any legal questions. Before turning over to Andrew, and as you will see shortly in the presentation, there was unfortunately litigation begun in this case before we were able to bring this enforcement matter to you. And I'd like to acknowledge and commend the work that the Attorney General's office has done in this case, and in particular, thank Deputy Attorney General Mitchell Risch. He was the lead in the litigation that upheld the Commission's prior permit denial going up through the Court of Appeals, and in our opinion, we wouldn't be bringing a consent agreement to you today without his help on the litigation front. One other introductory note, sorry for all the introductory notes, but we've also coordinated our enforcement action with the enforcement actions being undertaken by the LA County District Attorney's Office to enforce fair business laws, specifically State Business and Professions Code 17200, which is a law that addresses violations of other laws also as a business and profession code violation. The DAs initiated their case on the basis that the Shore Hotel was operating in violation of the Coastal Act. Working in parallel, both agencies have been working on resolving the shore violations, and they expect to bring their legal authorities following the actions taken by the Commission. And we can answer more questions if you have questions about the DAs later. But now Andrew will take it away to do the main presentation.
Thank you, Lisa. Good afternoon, Commissioners. Let's see, do I have the... Okay, slide 2. Staff is bringing this action to you to resolve violations related to unpermitted demolition of 2 low-cost motels and construction of a luxury hotel, the Shore Hotel, located here, just inland of the Santa Monica Pier. Slide 3. Here is the Shore Hotel, which is a self-described luxury boutique hotel. Slide 4. As Lisa noted, the issue of affordable accommodation is of particular significance to the Commission, since the Commission has a responsibility, pursuant to the public access policies of the Coastal Act, to protect lower-cost visitor-serving facilities along the coast and to ensure that new development projects provide for a range of affordable visitor-serving facilities. The Commission has found that overnight accommodations are a necessary part of providing public access for the many visitors that live further from the coast, where a coastal trip requires a lengthy car ride. For many low and moderate income visitors, affordable accommodations are essential to accessing the coast at all. Needless to say, one way that the Commission best promotes environmental justice is through ensuring that projects are consistent with the public access policies of the Coastal Act, and that public access violations, such as this one, are corrected in a manner that is consistent with the Coastal Act. Slide 5. This matter has a multi-layered history. The key events are listed here, including approval and expiration of a CDP for a moderately priced hotel, unpermitted construction of the luxury Shore Hotel, initiation of an enforcement case, denial of an after-the-fact CDP for the Shore Hotel, litigation over the denial, and then commencement of formal enforcement action. I'll cover this history briefly over the next several slides. Sunshine Enterprises did obtain Commission approval for replacement of the lower cost motels that were previously on this site with a moderately priced Travelodge hotel. You can see the project description for that CDP on the screen. However, the developer never got the permit issued, so it expired, and therefore the subsequent work was unpermitted. Slide 7. Moreover, even if the permit had issued, it approved the work on the basis that the project would protect affordable accommodations on the site, not a luxury hotel. In this photo, you can see the 2 lower cost motels that were previously on the site and were demolished. The Pacific Sands Hotel on the left and a Travelodge on the right. Slide 8. And this is the site after those motels have been demolished and the luxury Shore Hotel constructed in their place. Slide 9. As one measure of its luxuriousness, the room rates at the Shore Hotel currently range from roughly $300 to $800 per night. Sunshine Enterprises indicated in its application for the 2009 CDP that the room rates at the proposed Travelodge would be approximately $164 per night. Here's a photo of one of the hotel suites and some of the other areas of the hotel. Slide 10. When commission staff learned that the demolition and construction had gone forward despite the permit's expiration, and the developer had constructed a luxury hotel rather than the hotel that they had proposed, commission staff sent the developer a notice of violation letter in January 2014. After the 2014 notice of violation letter in January 2015, Sunshine Enterprises applied to the commission for a second CDP to obtain after-the-fact approval for demolition of the 2 low-cost motels and construction of a luxury hotel. However, in their application, Sunshine Enterprises did not propose any mitigation for the loss of affordable accommodation beyond the $1.2 million fee it had already paid to the City of Santa Monica when the city similarly found that the hotel was not a moderately priced hotel as proposed, pursuant to the city's codes. On September 9th, 2015, after a full public hearing, the commission denied the application due in part to the commission's finding that the project did not protect or provide for affordable accommodation and did not provide sufficient mitigation for loss of affordable accommodations resulting from the demolition of the 2 motels. Slide 11. Sunshine Enterprises then challenged the commission's denial of the project by suing the commission. The Superior Court upheld the commission's action and rejected Sunshine Enterprises' challenge of the permit process. In doing so, the court characterized their actions as a bait and switch. In July 2017, the executive director of the commission issued a formal notice of intent to commence cease and desist order and administrative civil penalty proceedings. The NOI provided formal notice of the commission's intent to resolve these issues through the administrative process, including through a consent agreement. Slide 12. Sunshine Enterprises appealed the trial court's decision, and in March 2019, the Court of Appeal affirmed the decision, upholding the commission's denial of the CDP as inconsistent with the Coastal Act. Although Sunshine Enterprises had appealed the trial court's decision, commission staff and Sunshine Enterprises worked together concurrently with the appellate litigation to reach an amicable resolution of this matter through the proposed consent agreement. Slide 13. In the next few slides, I'll go over the requirements for issuance of the components of a consent agreement, a cease and desist order, and administrative penalty, starting with a cease and desist order. The Commission can issue a cease and desist order when development, as defined in the Coastal Act, occurs without a CDP, without a required CDP, or occurs inconsistently with an existing CDP. Here, unpermitted development has occurred. Slide 14. The demolition of 2 existing motels and construction and operation of the Shore Hotel involve demolition and construction activities including grading and loss of access to the coast through loss of affordable accommodations, all of which constitute development under the Coastal Act and therefore require a CDP. No CDP has been issued to authorize these activities. The Commission therefore has jurisdiction to issue a cease and desist order to address these violations pursuant to Section 30810 of the Coastal Act. Slide 15. Even if the 2009 CDP had issued prior to expiration, the hotel that has been constructed is not consistent with the description of the project approved by the CDP. The CDP approved the construction of a moderately priced travel lodge, as is fitting, since affordability to a broad range of visitors was a central characteristic of the project first proposed by Sunshine Enterprises and considered and approved by the Commission. Slide 16. Through the consent agreement, Sunshine Enterprises has agreed to obtain a CDP for the Shore Hotel or cease operations. Following this item, the Commission will hear the CDP for the Shore Hotel, which includes a request for after-the-fact authorization of the existing hotel. Sunshine Enterprises and the Commission staff have worked collaboratively on recommended conditions of approval for the CDP, and in order to address the Commission's findings regarding the inadequacy of the mitigation of fee associated with the prior application, Sunshine Enterprises has agreed to the recommended conditions of approval, including payment of an appropriate mitigation fee, as described on pages 24 to 27 of the staff report for the CDP. That said, nothing in this consent agreement limits the discretion of the Commission in acting on the CDP. If the Commission were to modify or deny the CDP, Sunshine Enterprises could challenge the Commission's action in court. However, the obligations of the consent agreement would remain in effect, but the time frame for Sunshine Enterprises to comply would be extended. Ultimately, though, Sunshine Enterprises is obligated by the consent agreement to both obtain a CDP or cease operations and to pay the fine required by the consent agreement. The agreement also provides that Sunshine Enterprises will fully comply with the terms of the final CDP or cease operations. Finally, the consent agreement has other protections going forward at the site. Sunshine Enterprises has also agreed to not contest this consent agreement or its enforcement, and to not undertake any further unpermitted development at the site. The agreement also provides for stipulated penalties of $5,000 per day for each violation of this agreement. Slide 17. As part of the resolution of the violations before you today, staff is proposing assessment of a consent administrative penalty under Coastal Act Section 30821. 30821 allows the Commission to impose an administrative penalty for violations of the public access provisions of the Coastal Act. The unpermitted demolition of 2 low to moderately priced motels clearly does not protect lower cost visitor facilities, and in fact has resulted in the loss of affordable accommodations. Furthermore, unpermitted construction of a luxury hotel without mitigation fails to provide for affordable accommodation, all of which has occurred in contravention of Coastal Act Section 30213, amongst other policies. Slide 18. Under 3821, the Commission may impose penalties of up to $11,250 per day for each violation. Slide 19. To determine the penalty amount, Section 30821C requires the consideration of the factors shown on this slide. I will briefly discuss the application of these factors to the matter at hand, but please see pages 18 to 22 of the staff report for the consent agreement for a more comprehensive discussion of these factors. To summarize, we recommend that the Commission consider several aspects of these violations that weigh in favor of a substantial penalty. For instance, the subject violations have persisted for years, and the violations have meant that lower cost accommodations have been completely lost during that time. Moreover, the resource affected by the violation, access, is a scarce and important resource across the state. There is no restoration possible for the years lost that the low-cost motels have been demolished, and affordable accommodations therefore lost. The cost of the state to address this violation has been significant. And finally, Sunshine Enterprises has garnered significant economic profits from the violation through the operation of the Shore Hotel. On the other hand, perhaps the most significant mitigating factor to consider is Sunshine Enterprises' effort to largely work cooperatively in recent months to resolve this matter through a consent agreement, and their agreement to do so consensually. Slide 20. Aggregating the factors described above, staff recommends that the Commission impose the maximum administrative penalty for a violation of Section 30821. Multiple violations have occurred at the site, but for the purposes of this hearing, however, staff is recommending, due to Sunshine Enterprises' willingness to resolve this matter through a consent agreement, that only one violation be used for the calculation of this penalty amount. Staff also recommends that the Commission choose to exercise its prosecutorial discretion to limit the period for which the penalty is imposed to the period between July 1st, 2014 the effective date of Section 3821, to the date on which Sunshine Enterprises agreed to pay the appropriate monetary penalty. Staff thus recommends the imposition of a penalty in the amount of $15,581,000. Sunshine Enterprises has agreed to pay this penalty. The funds would be deposited into the Coastal Conservancy's violation remediation account. With this substantial amount of money, along with the mitigation fee required by the CDP, we envision use of the money to add much-needed low-cost options for accommodations that will help families from diverse socioeconomic backgrounds stay and visit the coast, including through such projects as funding construction or rehabilitation of affordable accommodation in the Los Angeles area, developing campsites in the San Monica Mountains, and increasing the number of rooms in a nearby hostel. Slide 21. In conclusion, this consent agreement will resolve significant Coastal Act violations by requiring the Shore Hotel to come into compliance with the Coastal Act and for Sunshine Enterprises to pay a significant fine. Staff has worked closely with Sunshine Enterprises to craft the proposed resolution. We appreciate the cooperation and willingness of Sunshine Enterprises to resolve this matter amicably so that we can bring this proposed resolution to you today. That concludes staff's presentation.
Thank you very much. Ms. Heggie, do you have anything else? Okay. Mr. Stacy, on behalf of the alleged violator.
Madam Chairman, Commissioners, good afternoon. Thank you for giving us this opportunity to bring the agreement we have reached with your staff before you for what we hope will be your approval. My name is Sherman Stacy. I'm here representing Sunshine Enterprises and the other parties to the proposed consent order. The owners of the Shore Hotel have worked closely with your staff to arrive at what we have agreed upon today. The owners are here today to seek your approval of the consent order. We vetted any number of proposals with your staff to arrive at terms upon which we could resolve the disputes between us. Your staff and the Shore Hotel have agreed that the measure of the penalty, which is severe, should be imposed. Under the consent agreement, Shore Hotel accepts the violation and the penalty. The coastal staff arrived upon a maximum penalty amount of $11,250 per day for each day until the Shore Hotel agreed that they would pay the penalty. It is more than half of the construction cost of the shell of the Shore Hotel itself. It is a considerable penalty on an enterprise that is operated by a family, not a chain of hotels or a large hotel developer. The one family owns the Shore Hotel. The owners now fully understand how the commissioners and the staff have viewed this violation. Consent to the penalty arises from realizing this understanding that you considered this far more severe than it was perceived initially. We are here today in full support of the staff recommendation and in agreement with the consent order. Under the consent order, Sunshine Enterprises gives up all of the defenses which it had asserted. Sunshine Enterprises is responsible to this commission for what we agree is a significant, unprecedented, and heavy penalty. It is the penalty the legislature established and vested in this commission the authority to determine how much and whether a penalty should be imposed. We have agreed to accept the penalty. We appreciate the work we have been able to do with your staff, with Lisa Hagee and Andrew Willis, Aaron McClendon, and Alexander Halperin, and your executive director, Jack Ainsworth, all of whom participated in helping us to reach the resolution that we hope you will reach today. We look forward to resolving the matter today and genuinely desire to put the matter behind us. Sunshine wants to move forward and work for public acceptance as a good corporate citizen who operates within the law and which can expect to be fairly treated in the future. As I urge for each of you to focus on the issue at hand, is this a penalty agreed upon for which we both give up the risk of not achieving a greater or a lesser penalty, since it was the maximum, and consent to and agree with your staff to the imposition of the consent order. I don't have a great deal to add. I could make arguments with regard to what the staff presents. They've characterized it as they see it. Since we've consented to the order, it serves no purpose for me to argue with you some different characterization. But I would reserve the balance of my time for rebuttal, and I urge at the conclusion of this hearing for you to vote to support your staff and its recommendation.
Thank you. Does Mr. Hernandez want to speak? Is he the owner? Says applicant. Isaac Hernandez? No? Okay. Thank you.
Mr. Hernandez?
No, that's okay.
Don't know.
Somebody just checked the wrong
Okay.
box. Okay. Okay, so I have a number of speaker slips here, quite a few. So I'll ask you how much time you need. I would like it if you could please keep it to like 2 minutes unless you have something really complex to say. And I'll start with Isaac Hernandez, if he's here. There we are. We'll be followed by Jerry Peck. Just get ready to kind of get going.
Hello, good afternoon. My name is Isaac Hernandez. I first met the Farzan family at a volunteer organization in 2009. Booyah, Building Unique Youth Alternatives, was a large organization where we will serve hundreds of low-income families that had troubled children. Our mission was to provide resources aimed at giving them opportunities to keep them away from gangs and drugs. The Farzans would volunteer hundreds of hours away from their own families to others in need. I was one of those troubled teens who successfully completed the program. In 2010, I was hired to provide security at the construction site, which was going to be the Shore Hotel. Thereafter, I was employed full-time for almost 8 years. The workplace was wonderful, and the benefits were amazing. While employed there, my father passed in a tragic car crash. The Farzans once again stepped up and helped my struggling family with all the funeral costs. Since then, I moved and now work at a different hotel, which happens to be unionized. I can tell all of you that Shore Hotel operates better than anything I've ever seen and really miss it. Please support them as they supported me and many others. Thank you.
Thank you. Jerry Peck, you're here, and then followed by Graham Hamilton. You have 2 minutes. Could you please state your name?
Thank you. My name is Jerry Peck. Thank you, Coastal Commission, for letting us have the time to speak today. I am the General Manager of Shore Hotel and would like to reflect on how Shore Hotel has supported the Commission's goal of protecting and enhancing California's coast since its opening. With these words, I'd like to express and underline how the hotel team works daily to ensure a sustainable Santa Monica and California coast for generations to come. Like the Commission, Shore Hotel does this by carefully planning and use of environmentally sustainable practices, including hotel design, materials use, team training, service and partner agreements, and more, all in strict compliance with the law. We also make a continued effort to share these sustainable practices in Santa Monica because community and in the hospitality industry, as well as with the general public with education and outreach programs. Just a few examples of how Shore Hotel carries out its promise as hotel committed to sustainability. Planning and governmental partnership. Shore was designed with environmental sustainability in mind, and in recognition of the careful planning, it achieved LEED Gold standard qualifications. Our sustainability planning includes incorporation of solar reflecting materials on rooftop to reduce heat islands, high efficiency toilets, low flow faucets and showers, automatic faucets and toilet sensors, as well as native plants and landscaping. We have also planned and enacted sustainable practices such as elimination of single-use plastics ahead of state legislature, even before those regulations came into effect. Science and development. Shore Hotel works with various agencies such as Southern California Edison for demand response.
Sir, your time is up.
Thank you.
Graham Hamilton here, and followed by Anna Evans Goldstern.
Thank you, Chair Boschko, Commissioners, staff. I'm going to read this to keep on pace. My name is Graham Hamilton. I'm the Surfrider Foundation Los Angeles Chapter Coordinator. I'm also a fortunate 10-year resident of Santa Monica, California. I'd like to congratulate this commission and your outstanding staff for all the work that went into and continues to go into your environmental justice and social equity policy. I can only assume that the issue before us today falls well within its mandate. And while I applaud the Commission for the administrative penalty that they're leveling, it indirectly raises questions about the inherent value of our communities and our coastal resources, which I'd like to underscore here. $15.5 million is an incredible sum, but does such a sum truly reflect the value of what has essentially been stolen from middle and low-income Californians who might like to spend the night near the Santa Monica Pier? Furthermore, how much will such a sum actually cost Sunshine Enterprises, a company that even now, facing such a seemingly serious penalty, is looking to expand operations in one of the densest and most affluent coastal communities in the state? If it's safe to say that a penalty is only as good as the lesson it leaves behind, what would the lesson be here for a company that breaks the law, pays a fine, and then is free to conduct business as usual without actually having to restore what was stolen in the first place? Lower-cost accommodations along the California coast are priceless, and we cannot afford to send signals to shady developers that the only penalty for illegally raising low-cost accommodations is a series of fines that will invariably be eclipsed by the financial gains they stand to make by running their luxury hotels. Surfrider LA and our 10,000 members, followers, and volunteers respectfully ask this commission to approve the proposed cease and desist orders along with the administrative penalty and deny application number 518-0872, or at the very least postpone the application until it reflects a one-to-one replacement of low-cost accommodations with similar proximity to the coast in the city of Santa Monica. Thank you.
Thank you. Thank you, yes. If you like it, you go like this. If you don't like it, you go like that. And following Anna, are you here, Anna?
I'm going to reserve my comments for the next item.
Oh, thank you.
Thank you.
Carl Holman.
Can I give my time to Jerry Peck for this?
Jerry Peck has already spoken. Do you want to speak?
No.
Okay, Molly Bass.
Baszler, I'm here.
Okay, do you want to speak?
Okay.
You don't have to.
Thank you, Commissioners.
2 minutes and just state your name.
Yeah, I'll probably be less. My name is Molly Baszler. I'm an environmentalist and a climate reality leader and a friend of Steve Farzam, the owner of the Shore Hotel. I support the approval for a coastal permit for the Shore Hotel. One thing that I think is really missing, especially in the
Excuse me, I hate to interrupt, but you're actually talking to the next item.
oh,
So 16A, anybody who wants to speak to whether or not they want a CDP to be granted speaks on 16A, not on a cease and desist. This is a totally different matter.
okay. So then, all right, then.
You want to speak then just
Okay.
put your card in for that.
Okay.
Or I'm going to call names, and
Someone put
anybody
my
who
card
wants
in.
to speak to 16A, just say you'll speak later, and just make sure that we've got a card on 16A. So that would be Scott Wagenseller? Seller?
Almost there.
Okay.
Wagenseller.
Okay.
Thank you, Commissioners. My name is Scott Wagenseller. I grew up in the Santa Monica area and still shop in the area. I support Sunshine's project down there, and glad to see that they've worked out an issue in regards to the penalty. I'm shocked at the amount that's been levied for this project, certainly as a business to have been improving the environment, doubling the access to the coast by doubling the amount of rooms and parking spaces. Just wanted to share that I know the Farzam family has worked very hard to make sure that this project is an environmentally sustainable and sensitive hotel. They've done an outstanding job in being LEED certified, and they have continued to be sensitive to their contributions to the community. They're a major employer now. They've added many jobs for the community, and I think that the effort on the behalf of the Coastal Commission and the hotel to work out this penalty phase should be approved, and they should be supported in their business. Thank you.
Thank you. Kelly Clark? Kelly Clark? Yes. Okay. And followed by Carlos Solis, and then Roger Gragetta.
Good afternoon, Commissioners. My name is Kelly Clark. I'm a staff attorney with LA Waterkeeper. I first want to echo the comments of the representative from Surfrider. We agree that Sunshine Enterprises must face significant consequences for engaging in their bait-and-switch scheme, claiming to preserve affordable accommodations and at the same time developing an unpermitted luxury hotel in Santa Monica. These actions must have severe consequences to deter future applicants from permits from deviating from the terms of their permits as approved by this commission. Moreover, while a fine and a cease and desist order is a good start to a reprimand, it doesn't ensure that there are even minimal opportunities for lower income individuals to experience what Santa Monica and the coast has to offer. This lack of affordable accommodations will persist as long as a hotel remains in operation here that does not provide access and rooms at a more affordable rate. Thank you.
Thank you. Carlos? And then Roger.
Good afternoon, and thank you for the opportunity. I am speaking in support of the penalty. My name is Carlos Solis. I am the Director of Food and Beverage for, for the Shore Hotel. I just want to let you know that we employ hundreds of people that are mainly in the inner city that otherwise will not have the opportunity to be close to the coast. And we not only employ employees that or people that will not have the opportunity otherwise somewhere else, but very young, without experience, and we make the effort to teach them, to train them, to make them understand of the hospitality industry. Otherwise, they will not be able to work in the industry, and many of them will probably be unemployed. So I am asking you to please consider and support of the penalty.
Thank you. Roger, you here? And following Roger will be David, oh boy, Famiano.
Hello, my name is Roger Gragetta, and I'm here in support of the Shore Hotel. I proudly work at the Shore Hotel. After I finished trade school, I was looking for a fresh start in a new career. At the time, I had 2 job offers. One of them paid 50 cents more an hour and was at less than a mile from my house. I was calling the Shore Hotel Human Resources Department to thank them and decline their offer. But after a brief conversation with the Human Resources Director, she told me what kind of company the Shore Hotel was, where they were headed, and what kind of green technologies they were going to bring. What she told me was that at a time, this was during the recession, that at a time when companies were pulling back on their benefits and cutting hours and cutting pay, the Shore Hotel was looking for ways to expand benefits and make it a better place for their employees. That got my attention. I accepted their offer, and I have never regretted it since. For the last 6.5 years, I wake up happy to go to work, where I feel I make a positive impact for our guests and our environment. Working in the engineering department, I have witnessed time and time again where the Shore Hotel spends enormous amounts of money and resources on green initiatives such as water-saving devices, LED lighting, and lowering our greenhouse footprint. The Shore Hotel is a great benefit to the coastal community of Santa Monica. Not only are we a Gold LEED property, but we provide a public area at the front of our hotel where the public can sit and relax. The Shore Hotel also provides low-cost parking and facilities for beachgoers. I have personally seen the Farzam step up and help their employees in times of need. They didn't do it for recognition, they did it because they truly care for their employees. The Shore Hotel is an excellent employer with great benefits and awesome opportunities. Thank you for this opportunity to speak in front of you.
Thank you. David, is it Famiano? Followed by Mario Aguilar.
Good afternoon. My name is Daniel Famiano. I'm a bartender and a server in a Shore Hotel for like 3 years and a half. I'm very proud to be working in a Shore Hotel because it's the only place I've been treated like a family. All the people is worried about us, and I've been working in the Santa Monica area for like 10 years. And then 3 years ago, I got the opportunity to get into the hotel. And it has been a great experience for me to be in that place with all the benefits that I don't have in any other place that I have been working before. And also without paying extra for those benefits that's supposed to be in some different hotels. They offer the benefits, but you have to pay the extra money for that thing. So I'm very supportive that you get the opportunity to get the permit.
Thank you.
Thank you very much.
Okay, Mario, followed by Javier Munoz. Thank you.
Good afternoon. My name is Mario Aguilar. I have worked for Shore Hotel since 2011 and now I am in the engineering department. What I want to let you know is that Shore Hotel gives the employees the opportunity to grow within the company, so you can move up to different departments and just do the best you can as long as you are a good worker. So that's something that I really appreciate about ownership. Also, I'd like to let you know that Shore Hotel has been, let's say, ahead of time when it comes to LED lights and being conscious about ways of preserving water and do different programs for the community and the environment. And also, I'd like to, sorry, I'm a little bit nervous. And also, the benefit for that we have in Shore Hotel, I consider to be a great benefits. We have a full health insurance, 401k, pay sick time, pay vacation, among other things. We have also a program that is a reimbursement program for all the people that instead of driving their cars to work, what they do is take public transportation or ride a bike like I do myself, and then they give you a reimbursement just for doing that, which is great. And also, last, I'd like to thank the ownership because they step up in moments of difficulty for the employees. They step up to help you. I'm saying it in a personal way because when my sister passed away, I didn't expect that to happen. And what was that happened like without me knowing? Ownership stepped up and helped me to cover all the costs, or not all, but most of it, which is, I bet you know that that's a lot of money. So, and that's it.
Thank you very much. Mario is next, and then Javier, and then Francisco Perez.
That was Mario.
Oh, that was Mario, I'm sorry. Yeah, Javier.
Hi, thank you. I'm going to be real quick, so I'm just going to read. My name is Javier Munoz. I believe for the most part people are good. People that put up a good front are usually telling the truth, but not in all cases. Sometimes their real self-interest cannot be hidden. My ex-girlfriend, Sandy, was one of those people. We used to live in East Los Angeles. She introduced me to a few people that were part of a church group called CLU. CLU stands for Clergy Lady United for Economic Justice. I was told by a man named Rich that they were funded by workers and stood for social justice. When we met them at a coffee shop around April 2016, I recall meeting a person named Carrie who said that they wanted for workers of all faiths. They told me that they were legal ways to make money. They told me that they had a member that was a lawyer that sued businesses. Sandy and I met the lawyer in Upland. He asked me if he was willing to move to Chino, if I was willing to move to Chino for a few months. I learned that I only needed to do this for a few months. I'm going to be quick because I'm running out of time here. Well, basically, I was promised to get $5,000 per month if I moved to San Diego. There was some type of an environment violation in Mission Valley. They came from a thing called Sivata. I moved again, and they only kept making me promises with no money. After their lies, I learned at KPBS that I was just one of dozen people that were taking advantage. Some of those lawsuits included Coastal Commission. As a Catholic, I could not continue to be part of this, and you don't need to take my word. You can Google this, and you can find that this is true under Friends of Glendora or Bill Barstow Smart. Thank you.
Thank you. Francisco Perez, followed by Sharon Fudge, and then Susan. Thank you. And again, just make sure I have a card for 16A if you didn't speak. Sharon Fudge, and then Susan Jordan.
Thank you. Good afternoon, Commissioners. Earlier, Chair Bochco said that somebody can ask a question, and perhaps you can pose it. I wonder why the Coastal Act allows for maximum penalties, but only allows you to collect 75% of those maximum penalties. It doesn't make sense when not only you have been duped, but the public has been duped. I've been trying to think of a corollary here, and it's almost like going into a restaurant and ordering a hamburger, having $5 in your pocket, and the waitress brings you a $50 steak and says, well, this is what you're eating now. Sorry, you're going to have to pay for it. And you don't have a choice anymore. Those lower cost accommodations have been wiped off the face of the planet. That penalty should go forward, and these people who somewhere made the choice to offer you one thing and then give us another should be penalized, and I believe to the full extent. I applaud what staff has gone through for years and years and years to try and bring this to a solution. And they've worked really hard, and I felt when the applicant's representative spoke to, well, this is what we've come to agree to, there was almost a veiled indication that if there was any other penalty thought to be put on here, that would not be agreed to. We're only penalizing them for one of their violations of the Coastal Act. So I believe that you still have a little bit of latitude here. And I hope that you take it. Thank you for your time.
Thank you.
Susan Jordan, the Director of the California Coastal Protection Network. In all my years, many years, I had brown hair when I started. I don't think I can actually recall a more flagrant, egregious, or deliberate violation, and I applaud staff for finally bringing this violator to account and by levying this sizable penalty, which I support, but I also have to ask myself and you if this fine approximates the value of what has been lost. Not one but two lower-cost hotels in Santa Monica where luxury accommodations are a dime a dozen and affordable accommodations are an endangered species. You know exactly what this developer has done. You know, let the permit expire, unpermitted construction of a luxury hotel, operation of an illegal restaurant which was not allowed in your original permit. So that's something to remember and keep in mind as you move forward. And while it's nice to see the developer agree to this consent order and fine, I don't believe it's adequate compensation for, again, the loss of two affordable hotels, the profits this developer gleaned during the 8-some years of illegal operation, including a restaurant and bar, which was not included in the original permit, or the established dollar value of a luxury boutique hotel in Santa Monica, which is surely worth many multiples of this fine. In closing, I applaud the fine, but I would think twice about combining this fine with any mitigation for a CDP. Those two things are entirely separate. They should not be considered together. I'm disappointed that they are actually on the same agenda. And I would be very careful to carefully review that, because there's things in that CDP which I believe reward the violator for this egregious behavior. Thank you very much.
Thank you. So that's our last speaker. Mr. Stacy, would you like to rebut or have more comments? You have 20 minutes left.
I'm not going to take 20 minutes.
Okay.
Most of what you heard was in support. Much of it was from employees of the Shore Hotel who are anxious for their jobs. That's what's on the line for them. But to get back to the issue at hand, this is a consent order. A consent order is where we don't put up a defense and the commission gets to decide whether or not the fine the staff has agreed to is the fine that should be imposed. As the staff indicated, it was the maximum fine for the violation. I believe that trying to place valuations on things that aren't subject to monetary value is very, very difficult. The legislature laid out money as fines, and that's the way things are remedied. They laid out an amount. If you want $15,000 a day, you have to go to a judge in the Superior Court. And, quite frankly, I'd rather be there, but I'm here. And we're here to try to see you support your staff and provide an approval of the consent agreement. To look at some of the things that were said, there were not specific things other than whether or not you should perhaps not impose the fine, and I think that would not be the direction the commission should take. The lower cost things were wiped out. I'll have to say a word. They obtained a permit. They mistakenly thought the permit had been issued and proceeded, when the city gave them a building permit, to build. They accept that those mistakes are something that they now have to be responsible for, and we don't any longer contest the ability of the commission today to impose the fine that is recommended in the consent order. And I don't think I have anything further.
All right. Thank you. Back to staff. Have any more to add?
Yes, we have a couple of responses. I think Andrew Willis is going to take the first crack, and then I'd like to jump in.
Thank you, Chair Boschko. I'll start with a point of clarification about a question's been asked about whether this fine will replace what was lost. I'll say generally staff is working towards that goal, but we're dealing with a couple separate pots of money here. We have a fine under Section 30821, and we calculated that based upon maximum fine for one coastal act violation. There's a separate proposed mitigation fee as part of the coastal development permit that you will hear, which is intended to replace the rooms that were lost in kind at a 1-to-1 ratio. And that's been calculated pursuant to the advice we've received from a consultant in that matter. So there's two separate pots of money here, but it's a substantial amount of money that we hope will be used to rehabilitate or reconstruct lower cost accommodations in the area. We've already started to look at different options. You might be familiar with the Topanga Motel at Topanga State Park, which has been sitting dormant for years. There's some opportunities, real opportunities to provide affordable accommodation in a location very similar to the Shore Hotel, and that's something we would envision this money being used for. That's the clarification I wanted to make.
And I just wanted to follow up because I think there was some confusion between the two pots of money, as Andrew was saying. And penalties are generally not used to make up for what was lost. Generally speaking, penalties are to create a deterrent and to have some punitive effect to people who violate a law. Under the Coastal Act, we are incredibly lucky because when we assess penalties, they go into a special fund, and we are able to, rather than just have those function as a deterrent, they're also used to fund projects that benefit coastal projects, which is fabulous, and it's different than any other statute that I'm aware of. So that, I think, gave rise to some of the confusion because in this case, and very often when we bring cases to you, people do restoration and things like that, and which involves replanting or things like that that they do in lieu of some of the penalties. Here, the money is going into the VRA, and we anticipate it being used for something that's sort of similar to what a mitigation would be used for. The mitigation fees under permits are intended to actually replace what was lost by the approved action under the Coastal Act. That's a completely separate thing from what we're saying. Here, though, the money under this violation action could be used for the very same thing. And we're excited about it because we have the opportunity here for the first time. Every time we've had an overnight accommodation matter or a permit come to you, we've gotten very small amounts of fees, and it hasn't actually been enough to aggregate and build and actually fund projects. We think that this chunk is large enough to actually, for the first time, build or fund a project. And we're very excited about the opportunity to replace overnight accommodations that are affordable in the coastal zone. And so that's why we're supportive of this. But I just wanted to sort of talk about the difference between the purposes of the money. And we can talk about it more if the commission wishes, but I would just note that this is, although one would always want to have a very high penalty, I would just note that this is 10 times larger than the next largest settlement we've ever had under the Coastal Act. I wanted, and the other thing is that if we have a settlement, and again, this is a judgment call, and your call may be different than ours, and we welcome, obviously, as always, the Commission's input and decision-making on this, but one of the benefits to settlement, one of the values that we factor in when we're deciding what's a sufficient enough penalty is the avoidance of litigation. We've had years and years of litigation here, and if we were able to settle this, we both avoid the costs of additional litigation and the delays associated with that. We really would like to start building something as soon as possible and not have the Topanga Inn and other places like that lie fallow. I think Alex wanted to make one more comment, but we're happy to answer any more questions that you all may have as well.
Yeah, just a brief related point regarding the two fees, but in relation to the idea that proposing this fine would effectively be allowing them to buy their way out of a violation. I wanted to just be clear that although Sunshine has agreed to pay the $15 million fee, that fine doesn't allow 15 plus. That fine in and of itself does not allow them to keep their violation. It's a fine levied against them for breaking the law. Separately, and in addition to that penalty, they have to go through the normal permitting process of applying for a permit to maintain the hotel. And they only get to continue operating the hotel if they get that permit through that independent review by you. So the fine is not in any way letting them buy their way out of the violation. It's penalizing them for the violation, and then they separately have to go through the process to determine if they get to keep it. Thank you.
Okay, thank you for that. Commissioner Vargas.
Thank you, Madam Chair. This is a really disturbing case for me, and the testimony that I heard is also very disturbing, particularly the way the I don't know what we call them, the applicant or whoever they are, the representatives of the Shore Hotel seem to have provided statements that are, if I'm being generous, just calling them disingenuous at the least. This is not something that's just come in front of us overnight. This has been going on for years and years and years. I've been on the commission for 6 years, and I think this has been in front of us at least for the majority of that time, and they started building almost a decade ago. The representative of the applicant mentioned that they're good stewards and they want to work well with the agency. Well, working well with the agency is not trying to sneak in a giant luxury hotel project underneath our noses and the city of Santa Monica's noses for almost a decade. The applicant mentioned that and their representatives mentioned that they are good environmental stewards because they have a LEED Gold hotel. Well, guess what? City of Santa Monica has building codes that almost you almost get a LEED Gold hotel certified if you follow their building codes. So they're not really doing anything extra special there as well. And then the representatives attested that they were really good to their workers. Well, we've seen over the past few years that they fired several of their workers for trying to express their constitutional rights to organize. This is not a good actor. It's incredible, especially for somebody like me that has fought over the past few years to raise the alarm bell of a loss of low-cost accommodations throughout the California coastline. We cannot afford to compromise and give up ground here for the egregious actions of what this applicant has demonstrated. It's almost textbook environmental injustice when we talk about the idea of, well, they knocked down these low-cost accommodations on absolute prime city beach real estate. We'll put them somewhere else, though. That is textbook environmental injustice being applied here. And we cannot allow ourselves to fall into this trap that, sure, they're going to pay some hefty fine, which, by the way, I think is paid over several years, which allows them the ability to do Trump-style tax write-offs. I just don't think this is a proper way to handle these violations. I don't think it's a proper way to show that we mean business when it comes to flagrantly violating folks. I don't think other developers are going to get the message that they shouldn't do this behavior. I think quite the opposite. If you look at the lowest room rate that they say that the range is, in the $300 range is the lowest room rate. 164 rooms over 365 days. You're talking about $18 to $20 million just on the room rates alone, not even including food and beverage. I'm not crying for folks that have to willfully violate the Coastal Act and multiple planning rules on the local level. I'm not crying for them because they have to pay a $15 million fine over 10 years. They're going to make that back very quickly. And again, it's a perfect example to other wealthy developers that want to follow the same playbook. Okay. Here's how we can game the system and get away with it. Okay. My recommendation to my colleagues is that if we could, I would like to not even talk about fines and issue a decree that says they have to knock the damn thing down. Those are my 2 cents.
No. There you go. Commissioner Peskin.
Thank you, Chair Bochco. Let me start with a few questions for staff, and I want to say, Ms. Hagee, that you and Mr. Willis, I know, had a difficult negotiation, and this is a consent, and I may or may not end up supporting it, but I have a number of questions, starting with, could you characterize the negotiations about the payment period? I share Commissioner Vargas's concerns insofar as past behavior is often a predictor of future behavior. I don't think that the state of California wants to have a 10-year relationship with somebody that's been suing the commission on and off for the last 5. I mean, this is kind of like the kid who kills the parents and then comes and asks the court for mercy because he's an orphan, right? And it's a little bit what's happening here. But can you characterize why this is a 10-year payment period?
Like everything else in a negotiation, it's a balance of interests, and very often in our cases, we are able to get a higher penalty amount if it is paid over a period of time. And we worked with the Shore Hotel representatives, and admittedly, we're relying upon their representations as to what they could afford. But we thought that getting a big chunk of it up front, and there's the vast majority of it is paid within 90 days of approval, if it were to be approved. And having $1 million a year for 10 years was actually not a bad thing. One of the problems we have with spending and funding projects under the VRA is that we don't know what money's coming in. We have no idea who's going to violate when. And so having a steady stream of funding over the next 10 years was actually an attractive factor.
Through the chair, I respectfully disagree. You can't do a lot with $1 million. I mean, if the mission here is to replace affordable visitor accommodations, actually getting $1 million a year isn't really helpful. Having a big chunk of money at one time to actually do a project is much more helpful. I mean, $1 million, this is California at the dawn of the 21st century.
Is that a question?
No, it's a comment. Well, let me take
I would just say, of course, you're right. And in a perfect world, getting all money up front is worth more. And we, in fact, do present dollar worth calculations to try to figure out how much it should have to go up. The idea was that the upfront chunk was large enough to fund at least one of these projects that we had our eye on. We were trying, in the middle of trying to negotiate and move this along quickly, to also scope out projects. We spent a fair amount of time trying to look to see how much expanding a hostel would be, to see how much it would cost to renovate the Topanga Inn. Some of the problems was that we were trying to look for actually like to like, and it was much cheaper to fund a campground or a hostel, but we were trying to find something that was actually similar to what was lost.
Well, similar to what is lost would actually be 87 out of the 164 rooms in the hotel. So, I mean, and I'm sure this is true for some of my other local government colleagues on this commission, we are all struggling with affordable housing, in this case, affordable visitor serving accommodations, and many cities now employ inclusionary housing schemes, or short of that, or in addition to that, a in lieu payment if you're not doing it on site. And I think many cities are learning, San Francisco is certainly one of them, that we want to incentivize on-site affordability. So that's all by way of asking, in these negotiations, did you say, hey, if you want to return 87 of these rooms back to the $150 range, we'll settle on that? Because I don't want their money, I want the hotel rooms.
I'm going to presume that was a question also.
That was a question, yes. Did
okay.
you negotiate to get them on site? And if so, did they say no to that? And how did we, I mean, why can't they just convert 87 of the 164 rooms to the price point that is set forth in this report?
Yeah.
Of $143.
Commissioner, there are two categories of responses I would give you, and you may find neither of them compelling. But in the first place, replacement of what's lost is the whole purpose of a mitigation fee, and that is the job of a CDP. When it comes before the Coastal Commission, that analysis is supposed to recompense the public for what was lost and to make the overall project consistent with the Coastal Act. That is not really the job of the enforcement action, that's the job of the permit action. Having said that, as I said before, we're trying to work in tandem here and be able to use the enforcement action to enhance the replacement that would be able to be funded under the mitigation. And secondly, well, there's three. Secondly, and this is really unfortunate, but one of the problems is they built out to the property lines. Normally, we do look for on-site mitigation, and we tried, because we agree with you that having it moved down further away may not be as attractive to the public, and it may not be like for like, but unfortunately the hotel was built to the four corners of the property. So then we looked at the option of potentially having some of the rooms offered at a lower rate. And there's two problems, and again, this is an odd conversation to be having in a public setting, but let us do so. We don't have a lot of staff to monitor room rates. It's very complicated and it's difficult. The rack rates in hotel, as you know from staying in them, it's very complicated and the rates go up and down. We frankly do not have people who are able to, we don't have staff to monitor this on a day-to-day basis. And then we looked at making just a proportion of the rooms lower cost so that it didn't go up and down, that just a certain number every day would be low cost. But the problem with that is, if you don't do an income test also, what you do is you have a windfall for some of the people that normally stay at a high-end hotel. They may call that day and luck out and get one of the cheap rooms. And that didn't seem to be effectuating it. So we were concerned about that. So then we thought if we tried to effectuate an income test or some kind of test of the person who could rent the hotel room, that's a doubly complicated factor. And I'm not saying we couldn't do it, but it would be a real strain given we have one person for like 3 counties to handle the entire enforcement, and to have that kind of detailed monitoring would be difficult. It's not impossible, but it would be difficult.
Well, it's not as though State Parks does means testing on the people who come and stay at the Topanga Canyon. It's just first come, first serve.
Exactly, and that was our original objection in the permit context, was that the type of hotel or motel you have is self-selecting to some extent, and you do get the right kind of people that you're expecting. I'm sorry, I'm having trouble seeing around, Jennifer. Sorry about that. But if you have a high-end hotel and you keep the rooms the same and you just make them sometimes cheaper for some people, and you don't do a means test, then I do believe that you are going to end up giving a windfall to people who would otherwise be staying in that hotel.
Then let me ask you another question, because they've litigated and it's gone up to the appellate court. And maybe you don't know the answer to this, or maybe this is a question for the AG, who bore the attorney's fees insofar as the Coastal Commission prevailed at each and every step in the trial court and then on appeal?
I'll let Alex handle that.
The petitioners, who are the hotel owners, paid their own fees for their counsel, and the Attorney General's office represented us. That doesn't come out directly out of our budget, so that would just be part of the Attorney General's manpower hours. There were no significant costs associated with the litigation because there wasn't extensive...
Adds to the commission. The California taxpayers paid their share to defend.
I assume that the Attorney General's budget comes out of the general fund. I don't actually know that for a fact, but yeah, I expect that's right.
But there's no provision for one side to pay the other side if they don't prevail?
Not in a case like this.
Right. And then the case report speaks to this Section 17-200 matter from the Business and Professions Code that the district attorney, the local district attorney is undertaking. Can you elaborate a little bit on that?
As I briefly said at the beginning of the presentation, Business Code 17-200 says that if you undertake business activities that are in violation of a law, that in and of itself is an anti-competitive behavior, and it's unfair business practice, which we agree with. So we reached out to the DAs and we were coordinating with them, but their cause of action is derivative, if you will have it. It's only because there's a Coastal Act violation, and when there's a Coastal Act violation, that then there's also a violation of the Business and Professions Code. They are planning, as we talked to them on Friday, they are planning on pursuing their action once ours is completed. And the Business and Professions Code is actually a little bit different than the Coastal Act. It doesn't look just at daily penalties. It's structured differently, and it allows a disgorgement of profit analysis.
Right. Thank you, Ms. Hagee. That's exactly where I was going. And this is not hotel math, and this is not business math, but this is math, which is based on the staff report. The room rate is between $300 and $800. If you want to take the mean of that, call it $550. If you want to subtract from that the room rate of the 87 rooms let's round it up by $7 to $150. That's $400 is the delta between what they built and what was there. And if you want to run those numbers, that's worth about $24 million a year. Now that assumes 100% occupancy, and it assumes that this, back in the envelope math is right, but that's $24 million a year, which gets me to the next thing. So obviously we do not have a disgorgement of profits remedy here, but we do have another remedy, and Lisa spoke to it, which is this is one violation, and this one violation is worth $15.581 million. But, Ms. Hagee, how many other violations are you waiving? And let me just say, that's $24 million a year for, I mean, depending on how you want to count it, from 2011 to 2019, or if you want to do it from when they got their first notice for 5 years.
If I may, I'll address this. The Coastal Act doesn't address the question of how to discriminate between different violations or how to calculate how many are at issue when you have a situation with a multi-step project with multi-components. And there are undoubtedly many different ways that this could be calculated and many different arguments that people could make about how to calculate the number of penalties. We certainly believe that there have been more than one violation here, but the hearing before you today is under Section 30821, which allows for the imposition of penalties for the violations of the public access provisions of the Act. And I think it's arguable that although the initial violation, the demolition of the pre-existing affordable hotels, was the first violation, once they were demolished, the impact to the public access had occurred. The damage was done, and what we could arguably consider as subsequent violations didn't make that impact worse once those hotels were already gone. So that was one reason that we looked at it that way.
All right. I want to hear what my colleagues have to say, but I'd say one thing that is a do not pass go for me, is the 10-year payment, particularly because if there are future problems or disagreements, I don't want the commission to be in a position where we're turning a blind eye to a bad actor because we're, waiting for that next $1 million installment. That's not good. And I guess I will ask one question, which is that out year $10 million is secured by what?
We don't have a bond, but we do have stipulated penalties of $5,000 a day, and the agreement also provides that if they fail to pay, or either the original payment amount or the stipulated penalties as assessed, that we have the right to seek a lien, and that they've agreed in advance that it has the dignity of a judgment lien. So we have some security, which is much more than our normal agreements have.
So maybe we could just do one thing before I relinquish the microphone, which is maybe we can hear from the applicant as to whether or not they would consent to a full $15 million upfront payment. Because if the answer to that is no, then I can't live with this consent.
You'd like to call Mr. Stacy up?
Yes, please.
If I could ask Commissioner Peskin's indulgence, while you have further discussion, I would like to be able to consult with my client with regard to the question.
Absolutely.
Thank you. Commissioner Groom.
Thank you, Madam Chair. Like Commissioner Vargas, I've been on this commission long enough to have been through every one of these hearings and have listened to several stories. This action to me is just plain dishonest. You've got approval for one, built another, and during that period of time when the lower cost serving were being torn down, a whole bunch of decent human beings lost their jobs and didn't have a way to make a living. The public, of course, lost the ability to have low cost serving for a number of years, and then when the hotel reopened, gosh, it was no longer low cost. So the state of California, the people who live in the state of California, lost a great deal on this. And again, I just want to say this has been dishonest. And whatever penalties we assess should be paid and should be paid in full. And I'll save the rest for when we get to a later item.
Commissioner Uranga.
Thank you, Chair Bosco. This is one of those situations where, it's an after-the-fact type of penalty that we're doing here. I mean, we've known for a number of years now that this applicant has been violating the law, that has been egregiously doing so. And its only way to remediate what it's doing is to pay its way out of it. Frankly, I don't even think paying $15 million today would be enough, especially given the 10-year process at your math, and you're talking about $250 million in 10 years. And taking $15 million out of that, it's a drop in the bucket. So, I mean, I'm not sure that this is a way to tell other developers that, you know, you can pay your way out of these penalties, or that you can also, you know, be so egregious as to say, you know, don't worry about it. You know, we can pay our way out of it. It's not a solution. I mean, short of following Commissioner Vargas's recommendation to just knock it down and do it over. I know we can't do that, and probably we should, but I'm not going to go that far. But the bottom line is that this is an applicant who has been purposely violating the law, has egregiously violated the coast, has egregiously taken away the opportunities for people to enjoy the coast in affordable accommodations. And it's much more egregious than just $15 million, in my opinion. But, you know, I'll let my colleagues go ahead and work this out, but I think that $15 million is just too cheap.
Vice Chair Padilla.
Sharing mics here. Thank you. Thank you, Madam Chair. Madam Chair, colleague, you know, the record in this case is particularly disturbing to review, and I'll be candid, looking at the testimony, I'm particularly disappointed in the testimony given at the initiation of this hearing, wherein there were statements made that this was a mistake, this was a misunderstanding. And that's an initial threshold here that I just can't get over. I mean, you know, this is a highly sophisticated organization, corporate entity, group of developers who clearly and overwhelmingly in the record were well aware of their obligations under the original permit, including at what time that permit would expire. And the record reflects pretty clearly that this was not oversight, this was willful. And that deliberate decisions that were made caused some damage to the state of California. And that's, I think, for me, the most disappointing element here. And so I know that there's probably additional dialogue with respect to how we might fashion the penalty piece here, but suffice to say, starting with the recommendation, I'm perfectly prepared to support the order and the penalty at this point, and I look forward to hearing some more dialogue as to how we might implement that.
Commissioner Brownsy.
Yes, thank you, Madam Chair. I'm wondering if the lawyer for the violator has an answer for Mr. Peskin and the commission.
There isn't cash that can be raised to make the payment, contemplating in my client's mind the potential of making an additional $8.5 million payment were the commission to take action on the permit. That's how they viewed it. It was how much money they could raise, and they agreed with the staff to pay one in cash, the mitigation, and have the more than a third paid initially, but the rest comes out of revenues because they can't raise that much cash. I mean, they own this hotel and one small hotel and a motel in Santa Monica. That's it.
Okay, just so I understand what you just said. The answer to the question is that you could raise it to, you couldn't pay the full $15 million, but you could go as high as $8.5 million.
No. What I said was...
Sorry, I'm glad I asked.
I think the more simple answer to be direct to Commissioner Peskin is, no, we're not able to pay the $15 million in cash.
In full.
In full.
Okay, Thank you.
I'm sorry, just for clarification on my own, you're paying when we get to 16A, you're paying that in cash?
Yes.
That mitigation fee in cash? which
That is offered in cash.
8 plus whatever
Right.
it is. So they're putting 8 million in cash towards mitigation, and then this is a separate fine of 15. Do you understand that?
The way I interpret what they said is that they have access to approximately somewhere between 13 and 14 million dollars is what, the way I interpret
Right,
that.
which is what is involved in this whole, okay.
All right, thank you very much. Like my colleagues, I do believe that this is a case of willful violation. I also believe this is a case where the loss to a sector, and actually the largest sector of Californians who have an interest in spending time on the beach, has been denied in perpetuity, because that access to not having to commute in, even from a place like Topanga Canyon, which is not that far down the road, but as we all know, could take an hour to get from there to Santa Monica most days. I'm troubled by the representation that these were just kind of inadvertent mistakes that occurred by this developer, because I don't believe that is the case. Otherwise, we wouldn't be having this conversation. So I, like some of the other members of this commission, believe that the amount should be paid in full because of the history on this particular case. And so in terms of the cease and desist order, perhaps someone will make an amended, I don't know if that's something that can be done with respect to the agreement, or if that kind of blows things up. So if staff could answer and respond to what happens if the commission seeks a different remedy. Thank you.
Sorry. This is brought to you as a consent item, and so you have the discretion to either propose additional changes, and we can see if the other party would agree, or you could vote yes or no. It's at your discretion, but we can't unilaterally impose new conditions here today. We would have to bring it back to you as a unilateral order, and then you could you would have a freer reign, but then they would have the right to sue. So it's just, there's two different ways of doing this.
Okay, thank you very much. Also, I would just say to my fellow commissioners that I would be very, I would not want to discuss the permit until the enforcement action is, that question on the enforcement action is settled, because I do not believe that I could really turn my full attention to the permit until the commission has made its decision on the enforcement action. Thank you, Madam Chair.
Commissioner Turnbull Sanders.
Thank you, Chair Bochco. I think one thing that we haven't had a full discussion on is the interplay of this matter with environmental justice. And although the environmental justice legislation specifically says that the commission may take environmental justice into consideration in issuing permits, in our policy, we also adopted general language around baking in equity within all commission actions. And I think this particular action is one that is critical and that needs to have that specific equity lens. And I think a lot of folks are confused about what equity is, and it's not just equality, but also looking at the historic wrongs that have occurred over time. In March, we adopted our environmental justice policy, wherein we discussed the particular circumstances that exist in Santa Monica, wherein, and specifically, there were large portions of African Americans that had thriving businesses in Santa Monica. And we talked about the destruction of a thriving community for the building of the Santa Monica Civic Center, where African American families and businesses were literally pushed out and burnt. Some of their homes and businesses were burned to clear the way, to make way for the auditorium. And so as we look at this particular case, the Bay Street Beach Historic District is now up for designation on a state and federal historic registry. And this is just almost immediately adjacent to this particular site. And so just providing that for some historic context. And I think it's important as a commission that we look to those historic wrongs and look at how this now plays out into generations following those who were forcibly removed, and thinking about how do we take action that doesn't end up repeating those inequalities and inequities of the past with a state kind of sanctioned action. And so I would like to very much associate myself with Commissioner Peskin's remarks. I think we have to look at a like-for-like replacement. You look at the transit lines that are in Santa Monica. We now have an expo line that ends up right out by Santa Monica Pier. This particular area would have been immediately accessible by inland communities, by affordable transit. Topanga is not. And so I think we have to take those considerations as we're thinking about what kind of penalty is appropriate.
Thank you. Very good. Commissioner Amanzada. Oh, do you want to make a comment?
I just wanted to make, I wanted to say that we completely agree with Commissioner Turnbull Sanders that we believe that this case it's our premier environmental justice case in the enforcement unit, and the staff report, we didn't highlight it a lot in the presentation, but the staff report talks about it extensively, and we very much view this as an EJ case, and that we could not agree more that one of the issues is trying to protect certain communities and the values that they present, and to try to make sure that the access is seen through an EJ lens, and we very much agree. And there's a summary of it on page 24 of the staff report, but there's a longer discussion inside as well.
Thank you. Commissioner Amanzada.
Yes, thank you. I don't want to repeat what's already been said, both by commissioners and by public comment. I'll just associate myself with the remarks of Commissioners Vargas and Peskin, and especially Commissioner Padilla as well. I don't know if it was the perspective of the clients or the representative, but it really was not well received to gloss over these flagrant and well-documented violations. And to the extent that our discussion and decisions here today send a message or don't to other developers, that is unacceptable. There is clear documentation of what has occurred, and to show up before us and present in a dismissive or minimizing manner is absolutely unacceptable. I also want to recognize that I think staff has done really good work in trying to get real money in the door and try to, as our attorney Lisa Hagee put it, start to address these wrongs. It's not perfect, and I don't know if it will be acceptable to this commission, but that also resonated with me, that this is one of the biggest penalties in history. We could actually start taking action to address the issue. So I agree with all the commissioners' remarks that it's not enough, and it doesn't make us whole as a state. But it is also significant. So, thank you.
Okay.
I've got a question.
Okay. All right. Go ahead. Commissioner Peskin has a question.
So, Ms. Hagee, for the sake of discussion, if we were to ask for all of the fine, assuming we could live with a fine that everybody seems to think is less than it ought to be, if we took the consent off of here, I realize we cannot do that today, you could go and enforce against that, correct? I mean, what happens if we say no to the recommendations that are before us right now?
We will have to make a choice about how to best bring it back to you. We could either attempt to have further discussions with the other party, or we could bring it back to you relatively quickly as a unilateral order. We just need to renotice it and bring it back to you at a later hearing. Alternatively, we could seek judicial action.
Okay. So the way I see it, there's a little bit, and I hate to do this in public, but there's a little bit of latitude for negotiation, which we can do right now, which is what counsel for the applicant said is that they have access to $13.8 million. And if we can do this in 12 months or 18 months and be done, I could get there. Now, that of course means that they're going to have to find another source of money, assuming, depending on how item 16A goes, to figure that out. But frankly, that's not what's before us. And so, I mean, if counsel wants to confer with their client and consent to something like 13 at close and another 2.581 within 12 to 18 months,
then you would be all right with that. Okay, well, I'm going to weigh in. What? I'm going to weigh in. I mean, I've listened very closely to this, and I personally have such incredible regard for our enforcement staff, and I know how hard you work, and I know how fair you are. And I personally am a little confused because I kept hearing throughout the hearing that this was the maximum penalty allowed under law. So, again, going to Commissioner Peskin's question, where we say, no, you know, this just isn't good enough for us, and I have some remarks about that too, but what else? There is no more penalty money available, if I understand what you've said about maximum penalty.
Alex wants to take it.
I mean, go ahead.
So there are basically three factors that go into calculating a penalty. There is the determination of what the daily penalty amount should be based on the factors listed in Section 30820C.
Could you talk a little louder in the mic? Thank you.
Sorry, the first consideration is what the daily penalty should be, and that is supposed to be based on consideration of the factors in Section 30820C. The maximum is $11,250 per day.
Okay.
The second factor is determining how many days you're talking about.
Okay.
And the third factor is determining how many violations you're talking about.
I see.
So this is the maximum penalty, the maximum per day penalty. It's the $11,250. But it was for one penalty, and it was for the period of time from when the statute became effective to when they agreed to pay it.
Right. And does the statute require we use its time of being adopted as our date, or do we have the discretion to go back all the way to the beginning of the project?
So the statute doesn't say whether it has any retroactivity, but there is also a 5-year limitation that is explicit in the
That's true.
statute that we
Oh,
can
you're
only
right.
cover
Okay.
a 5-year period.
5 years limitation, got it. Okay, because here's what I'm hearing, and maybe I'm reading the commission wrong, but it seems to me, I mean, we're all up here doing some kind of math, but obviously we don't know what their overhead is, we don't know, what other obligations they have, so we can't really just say, oh, gee, it's $250 million over 10 years. I mean, that's not what it is, I'm sure. But I'm sure it's significant, otherwise we wouldn't be here fighting about it. But I would say, from my point of view, perhaps the best thing to do is deny it today, have enforcement go back and sit and negotiate, and get more detailed information for us for next time you come back about what they're really making in terms of their profits. And even though we can't siphon profits the way the city can, what we can do is certainly look at that as a measure of whether this penalty is sufficient or not, in light of what Alex just said. I mean, we can't go back more than 5 years, and we can't charge more than $11,250 a day. So there are limits to what we can do. The second thing I would like to hear is to address what Commissioner Turnbull Sanders said, which is like for like. I think that's a really important concept, because in looking at 16A, if we get there, a lot of what we're saying about that is, the mitigation of $8 million is going to go towards hostels and this and that. That's not like for like. And I think it's time, and we've had this conversation not in the enforcement so much, but in other areas, that what we need to start looking at is the way to get people low-cost accommodations where they should be, by the pier, by the better beaches, and I'm a person, if the Topanga project is those little bungalows there up by, I love that project, but that isn't the same as being right at the end of transit destination or near the pier and the broadest beach we have anymore in Southern California, which is Santa Monica Beach. So that would be my recommendation, is we don't consent today. We send enforcement back with as much information as possible in terms of what we can get and addressing some of these issues, and there may be even other issues you guys want to bring up, but that would be my recommendation. Commissioner Vargas.
Commissioner Bochco, I don't oppose to your thoughts and ideas of what direction this should take, and I appreciate your perspective on this. I think there was, I do want to ask the staff, so we've talked about maximum penalties, but I think we're talking about maximum financial penalties, in other words, dollars that would be attributed, not necessarily other conditions that could be imposed. I'm wondering if I can ask staff, in addition to the maximum fine of $15 million, could we also in this decree, or whatever we're calling this thing, agreement, require, again, Commissioners Peskin, Bochco, and Turnbull Saunders have all brought up this concept of like for like, and Peskin, in his initial comments, actually stumbled upon something that kind of put a light bulb in my head. We don't have to go around searching for rooms that are near this place. There are rooms, they built rooms. So can we add a condition that a percentage of the existing rooms that they now have as boutique luxury just get turned into affordable lodging? That's the elegant solution, and that's exactly how you don't build something 5 miles away, a mile away, a block away. They already built it for us. So the state of California is owed a percentage of those rooms as affordable accommodations. Is that something that could be added, or is that also seen as a addition to the financial penalties?
In the first place, I want to be clear. I didn't get to respond to Commissioner Bochco, so if I can do a sideways quickly, just because there are additional penalties that could be brought, and in fact, if we were to sue in court, we would seek additional penalties under 30820. We brought to you penalties under 30821 because that's all that we can assess administratively, but it kicks it up to $15,000 a day as opposed to $11,250, and also there are additional provisions that could be sought. I think what you're getting at, and to switch back to Commissioner Vargas, which I do think that those are ideas that we are interested in, but they're more fitting in the permit context, because that is typically what we do as a commission, is require a number of rooms to be affordable under the permit context. I'm not saying we couldn't get them to agree to it here. I mean, in a settlement, anybody can agree to anything, and we have been creative in the past in our settlements, and we could be creative here if we had a willing partner.
And that's my concern, is we've got a partner that's being a little clever by half here, and has not displayed a tendency towards cooperation and partnership and collaboration over the past decade. So I don't want to have this be a twofer where we decide half of the penance on one and the other half the next time around. I want to make sure that these guys can't wiggle out of their responsibilities to the state of California. I'd really love to see this happen all in one agreement.
Okay, Commissioner Brownsy. Oh, Does somebody want to comment here?
Just
Okay.
as a legal matter, to answer your specific question, I mean, the penalty is imposed under Section 30821, which is an independent form of authority from your authority under Section 30810 or 30811, which allow us to impose cease and desist orders and restoration orders. We also have a separate requirement in the order that they simply cease operating if they don't get a permit. That's pursuant to the cease and desist order authority of Section 30810. We hadn't really considered, I don't think, whether we could impose a restoration order under Section 30811, which would effectively restore the rooms, which is, I think, what you're asking, basically. And the main reason we did that were the reasons that Lisa articulated earlier about the complexity of trying to enforce something like that and about whether it would actually result in the population that we would be trying to serve actually achieving the benefit. But it is, I think, legally possible to consider that.
My 2 cents is to get them to consent to that, and we'll figure out how to enforce it later, because once these, as we know, once these units are gone, they're gone forever.
Commissioner Brownsy.
Okay, and I apologize to the commissioners if I'm repeating myself. So I have some questions for staff just to try to understand it via the Peskin comments, which is one, my understanding is for the enforcement, although there's been some clarification that you could add additional things, that it's the penalty for the public access. And so the question for me is the additional issues that were raised by the commissioners with respect to like for like and the other really important issues associated with EJ and like for like and those things. Now, is it more proper that they come up as part of the permit action, or is it, do you think, more efficacious to postpone and include them as part of an enforcement action? Because the thing I'm a little worried about is we do have an enforcement, potentially a deal based on a payment schedule at this point, which could be very advantageous, but the permit issue is completely separate, and what's the latitude there?
Well, I'd point out that this input, certainly regarding seeking like-for-like replacement, is helpful in this context as well as the permit context.
Okay.
We will be able to work on, if the fine is assessed, work on use of that money for something that will be as closely a replacement to what was lost as possible. So this conversation is really helpful in this regard. But the actual analysis under the permit is where that conversation about what type of money would be required or needed to replace the lost motel rooms in kind. That is where that conversation would be, is, you know, what was lost, how much is necessary in order to build either rooms on the site or motel rooms in the area that are accessible by mass transit.
Lisa.
Can I ask you a question?
Sure, Madam
I
Chair.
just need to clarify from my commissioners here. My commissioners, I love that. Since we do have 2 actions here, we
Right.
have the consent and cease and desist, and then the permit action.
Right.
And there's money involved, and there are issues that can be addressed through one and not the other. Is it just by definition, after all of these questions that we've had, just better to postpone this, send staff back with instructions of what you prefer to see, and they can decide between themselves how that money, if it goes under 16A or if it goes under, because at this point, we can't really weigh the 2, it seems to me. It's getting very confusing.
It is, Madam Chair, and I was actually going to address that because the timing, because one of the things, now some of you have been familiar with and have been involved with this issue for multiple years. This is, to me, a very long-term enforcement matter and obviously a permit matter. The thing that I'm worried about is that we could be adding years to this negotiation. And I'm concerned about that because I actually want to just ask the commissioners if there was an ability to get the violator to agree to the larger sum with a shorter repayment, with a shorter payment period. Is that not something that we should consider and then have the more substantive, complicated conversations with respect to the like for like and all of those other things with the permit? Because to me, the timing of this is, I really think that having some resolution on the enforcement matter will really signal how we can then proceed on the permitting matter. And so either, Madam Chair, if you could ask the Violators Council to see if there is some movement on that, if that's acceptable.
The payment
Yeah,
schedule?
accelerating the payment schedule so that there's a bigger chunk and a shorter time period.
Madam Chairman, in response to Commissioner Brown's question, I would need more time than the few minutes I had to go outside and sit down and discuss. I would ask if you would trail the matter, go on to other matters, skip 16A for the moment, do other business. You've got other people here. Let us do it, and notify your staff when we're prepared to address you again.
Okay. I think that's a very good idea, actually, because we would like you to really think through this, thoroughly, because I know it's a lot of money and a lot of people involved. And so thank you. So we'll just trail this for now. Is that how we'd proceed?
I would just like to trail it for a certain amount of time, because I would like to have some completion by the end of the day. I'm worried that,
That's what I think Mr.
Yeah,
Stacy is saying.
This is trailing today.
Just to the end of
During
the day.
the day.
Okay.
Because we'll take other items, and then we'll get back to them, and we'll do 11 and 12, and maybe 16.
Okay, great, thank you.
All right. Okay, as soon as, where did everybody go? Please, commissioners, sit. Sit, stay, roll over. Okay, are we ready? Are we ready? Okay, let's go.
Good afternoon, Commissioners. We're back again with a continuation of the hearing on consent, cease and desist order, and administrative penalty 19 CD01 and CCC 19 AP02. At the Commission's request, and with an attempt to capture the general spirit of the Commission and their desires, we worked on some additional provisions and discussed them with the respondent in this matter. And we have another proposal to present to the Commission for your consideration. And Alex Halpern is going to read the actual language into the record. It's an amendment to section 6.0 of the order, which is on page 3 if you want to follow along the unamended version, but it has to do with the payment schedule and the conditions of payment. Alex? I'm sorry, it's page 3 of the order. It's section 6.0. But
So if you turn to the appendix, which follows the staff report immediately.
It's Appendix A. It's right after.
Appendix A.
So
And then you go to page 3 of the appendix.
it's 6.0. Exactly. Appendix A.
Appendix.
There's both.
Are we ready?
Yes, I think so. So, yes.
So the first sentence simply lists the amount. That's not changing. The second sentence this is a long sentence, and that talks about the payment schedule, but that's going to be simplified to simply state, respondents have agreed to and shall pay a monetary penalty in the amount of $15,581,000. Respondents shall pay the monetary penalty in 2 payments, with the first payment of $13 million made within 90 days of the effective date of these consent orders, and the remaining $2,581,000 to be paid within 18 months of the effective date of these consent orders, and secured in the interim by a letter of credit approved as to form by the executive director and provided within 90 days of the effective date of these consent orders.
Okay.
And Mr.
Sorry.
Stacy is here to indicate the respondent's consent to
Right.
that alternative language.
Sherman Stacy, on behalf of the respondents to the consent order, we would agree to that modification in the consent order and can rearrange funding and figure out later where to find the money
Okay,
for
fine.
mitigation.
Thank you very much.
So
Commissioner Peskin.
with that, just to be clear, so with that agreement, we, staff, are now hereby amending our proposal to recommend that you adopt the modified version of the orders, and it remains as a consent proposal.
Thank you. Commissioner Peskin.
Madam Chair, colleagues, I want to thank staff and the representative of the applicant for listening to the desires of the commission that seem to be quite unified relative to Section 6 of the cease and desist order, and I would move, based on the fact that this is acceptable to the applicant, as represented moments ago, that the commission issue consent cease and desist order number CCC-19-CD-01 pursuant to the staff recommendation with the language that was read into Section 6, and I recommend a yes vote on the foregoing motion.
Okay, seconded by Commissioner Brownsy. Would you care to speak any further, Commissioner Peskin?
I think everything that needed to be said has been said quite a lot.
I agree with you, Commissioner Brownsy. All right. The makers of the motion are asking for a yes vote. Any reason to have a roll call vote, or do we have a unanimous yes? We have a unanimous yes, so the motion passes.
And
Madam
there's
Chair, I move that the commission issue consent administrative civil penalty number CCC-19-AP-02 pursuant to the staff recommendation and recommend a yes vote.
Okay, the makers of the motion are asking for a yes vote. Any unwillingness for a unanimous yes vote? Seeing none, the motion passes.
Thank you very much. We greatly appreciate it.
Okay, and are we still desiring to go on to 16A? We are. Okay,
Yes.
let's do it.
Well done, Brownsy. I get my 1% finder's fee. I am set to jail.
All right. If we could bring up the PowerPoint presentation for this item, please. Amber Dobson, the District Manager for the Commission's South Coast District Office, will be presenting this next item.
Okay. Item 16A, the applicant, Sunshine Enterprises, is seeking after-the-fact approval for demolition of 2 separate lower-cost motel rooms and lower-cost motels, and construction of an approximately 89,000 square foot, 45-foot high, 164-room hotel with high-cost overnight accommodations to include 860 square feet of restaurant and bar and 2 restaurant commercial spaces, one with frontage on Ocean Avenue and one with frontage on 2nd Street, A total of 284 parking spaces and a 4-level subterranean parking garage is proposed to serve the development as well as the other proposed parking uses, including a car rental facility, distribution of monthly parking passes, and a valet program. Improvements to and the use of approximately 3,000 square foot commercial space with the frontage on 2nd Street as a restaurant is a new addition to the proposed project. In 2009, this space was approved by the Commission as a retail space. The major issue before the Commission today is the mitigation for the loss of the lower cost overnight accommodations. Next slide. And the next one. And the next one. As explained by our enforcement staff, in September 2015, the Commission denied CDP application 515-0030 in part because the recommended mitigation amount, which was approximately $3 million for the loss of the lower cost overnight accommodations, was found to be insufficient to bring the project into compliance with the Coastal Act policies to protect existing and encourage new lower cost visitor serving facilities. Following discussions with enforcement in August of 2018, the applicant filed the subject application again, seeking after the fact approval for the demolition of the hotel and construction of the new hotels, and the subject staff recommendation is consistent with past direction regarding the in lieu mitigation fee. The constructed hotel today differs from the project described of 2009. The constructed hotel is a self-described boutique hotel. The overnight rates are not considered low to moderate cost. The underground parking garage incorporates many new parking uses and costs the hotel guests approximately $45 per day per car. Additionally, in 2013, the applicant applied to the City of Santa Monica for an amendment to eliminate the limited amenities of the hotel and to pursue a conditional use permit for the bar and lounge and other services. The City of Santa Monica approved the project but prohibited the restaurant on site from being operated by the Shore Hotel and also prohibited direct room service or other direct public access to the restaurant from the hotel. Next slide. In 2009, the applicants had proposed to charge $164 per night, which was considered low to moderate cost at the time. A condition of approval imposed by the City of Santa Monica in 2009 required payment of a mitigation fee of approximately $16,000 per room for the loss of the 72 lower cost hotel rooms in the event of a price increase in the room rates. Likewise, the Commission conditioned the 2009 project so that any changes to the project, including a change to the type of the hotel proposed, would need to be reviewed by the Commission to determine if any mitigation was necessary. After the construction was complete, the applicant increased the room rates and submitted that mitigation fee to the City of Santa Monica. The applicant was informed by the city at the time that the mitigation fee would be subject to review and approval by the Commission. Today, the hotel room rates currently range from approximately $300 to $800 per night. The statewide average daily room rate in 2018 was $168 per night. The Shore Hotel far exceeds the statewide average and is currently operating as a high-cost hotel. In order to find consistency with the Coastal Act policy to protect, encourage, and provide lower-cost visitor-serving facilities, the Commission has imposed in lieu mitigation fees on development projects that remove existing lower cost accommodations and or propose only new high cost overnight accommodations or change the land use to something other than overnight accommodations. The Commission has regularly imposed an in lieu mitigation fee on hotel developments that remove low cost hotel rooms and or do not provide new low cost hotel rooms at the rate of $30,000 per room with inflation since 2007. Next slide. Following recent questions regarding the adequacy of the in lieu fee at Commission hearings, Hosteling International provided an updated report in 2014, which calculated the construction cost for new hostel beds based on square footage and found that new construction cost for a hostel bed is approximately $42,000 per bed without the cost of land acquisition. An independent consultant, Maurice Robinson, was hired by the Commission to verify the report's figures in 2015. The consultant concluded that $42,000 for new construction of a hostel bed is an accurate figure. The cost for construction of new hotel or motel rooms, he noted, could be calculated as 2 times the cost of a hostel bed because hotel and motel rooms require approximately twice the square footage as one hostel bed. Lastly, the cost estimate was based on 2015 construction costs. In the past, Commission staff had calculated changes to the in-lieu fee based on changes in inflation using the Consumer Price Index. The consultant states that the construction cost can be indexed on an annual basis by applying the Turner Building Cost Index, which is a specific construction industry index, and applying the most recent index to the cost estimate yields approximately $100,000 per motel room. The consultant's results of the calculation of the in-lieu mitigation fee was presented to the Commission during a recent lower cost overnight accommodations workshop, but has not yet been approved by the Commission in the context of a permit application. The mitigation fee of $100,000 per hotel room or per room is significantly more than the $30,000 per room plus inflation that had been used in past Commission actions. The consultant also recommended that land costs be calculated separately from construction costs. Consistent with the consultant's recommendations, the Commission staff has worked with other public entities, including state parks, the Mountain Recreation Conservation Authority, and the Coastal Conservancy, to identify several potential projects to receive the mitigation funds. And if mitigation funds are directed toward these agencies, then the question of land acquisition cost is not applicable because these organizations already have publicly owned land on which new lower cost accommodations could be constructed. Projects identified as potential to accept the mitigation funds for this project would include the Topanga Inn in the Malibu area, as well as other potential projects in the Malibu area in cooperation with the Mountains Recreation Conservation Authority. Next slide. The Commission has found in past actions that the loss of lower cost hotel and motel units should be mitigated at a ratio of 1:1. A total of 72 lower cost rooms were demolished, and consistent with past Commission action, mitigation in this case would be required for the 72 lost rooms plus 25% of the new high cost rooms constructed for a total of 92 rooms. So the total required mitigation amount is $9.5 million. The applicant did pay an in-lieu fee directly to the city as a condition of the city's local permit. The fee imposed was approximately $16,000 per room based on a very outdated formula in an ordinance approved by the city in 1990. The total amount paid directly to the city was approximately $1.2 million. Although the city program to accept the fee is not certified by the Commission as part of the land use plan for Santa Monica, the intent of the city's program is consistent with providing lower cost accommodations in the coastal zone, and therefore it is appropriate to accept the fee paid to the city as an offset to the total mitigation required. As such, special condition number 7 requires the applicant submit the remaining in-lieu mitigation fee of approximately $8 million. The applicant did propose this mitigation in the subject permit application and is in agreement with the recommendation. Other special conditions of the project relate to future changes to the hotel, indemnification, a deed restriction, a general occupancy requirement, and a transportation demand management program. There was an addendum to the staff report that recommended a couple of changes to the conditions. The applicant responded to some concerns raised by the opposition and agrees to have commercial tenants provide full reimbursement for employee transportation and supports changes to the special condition 6. There is one additional change to the condition that was not in the addendum, but it would be to change section 6 of condition 6 to provide for free public transit passes to all employees instead of just the free bus passes. Additionally, the addendum recommended a change to special condition 7 for lower cost overnight accommodations to clarify that the priority use for the mitigation funds is for the development of new lower cost hotel and motel rooms as opposed to hostel beds or campgrounds. Staff recommends approval as conditioned, and the motion and resolution are on page 6 of the staff report. Thank you.
Okay, there's no ex partes. So, Mr. Stacy? How many minutes would you like, sir?
I'd like 15 minutes, and I'll hold a portion for rebuttal. I'm concluded.
Okay.
It says good morning, Commissioners, on my sheet. Good evening, Commissioners. My name is Sherman Stacy, and I'm here today on behalf of the applicant. First, the applicant is in full agreement with the staff report and recommendation and all of the special conditions that have been proposed. These special conditions were carefully formulated by your staff. The Shore Hotel agrees to fully comply with all of these terms and conditions. Although several conditions are revised from what the Commission had before it in 2015, the central condition is the change in Special Condition 7, which calls for a fee to mitigate the loss of lower-cost accommodations. For about 3 decades prior to 2015, this Commission had based mitigation for the loss of lower-cost hotel rooms and motel rooms on the anticipated cost of constructing a structure to house a hostel bed. That was the formulation the Commission used, and it came out initially with numbers that were as low as 8,000, grew to 30,000 in the mid-90s. It has now grown to 100,000 because the staff has taken a change in the formulation. Rather than looking at the cost of replicating a structure that would have one hostel bed, they are asking you to approve a mitigation for the cost of replicating the construction of a motel room. The $100,000 is your consultant's estimated cost for the construction of a motel room, so that by paying $9.5 million, we pay for the construction cost of 95 motel rooms. Those then get used as funds to develop projects of that nature cooperatively with other organizations. And the staff thinks that the work you have done over the past several years on lower cost accommodations, along with that of the State Coastal Conservancy, have increased the potential that those funds will be used efficiently. This change, of course, is a significant increase from the amounts that you found inadequate in 2015. So we believe that they do, in fact, mitigate the cost of the construction of the rooms which were demolished and a portion of the rooms that were constructed. Encouraged by your staff, we had spent a considerable amount of time and formulated several proposals partnering with other public agencies or nonprofits to improve or construct other lower-cost alternatives. None of these proposals satisfied the staff's view that the mitigation needed to have a closer like-to-like relationship to the old motels. Therefore, the staff concluded that a mitigation fee equal to the construction cost was appropriate. There's always a criticism that money doesn't equal actual construction. But as I indicated, other agencies of the state have begun to participate more readily in utilizing funds available to create lower-cost accommodations. Most of the opposition that I've read in writing asks you to deny the permit. The staff disagrees and the applicant disagrees. Denial of the permit would result in protraction of the dispute that we have, would compel the closure of the Shore Hotel to no benefit to anyone, a considerable harm to the Shore Hotel. It serves tens of thousands of visitors every year. It has 160 employees. and we wish to avoid the closure of the hotel. We ask the Commission to allow us to put this matter behind us, to give due regard to the recommendation of your staff, and I am not neglecting the comments you have previously made to me today, but we believe that the staff, this is our second time with a recommendation that provides for a mitigation fee. The mitigation fee is the highest mitigation fee ever asked or paid in the state of California. And we think it does, in fact, cover the cost of being able to replicate what was demolished, those units that had been there, and provide new units that will engage people's access to the shoreline for many years in the future, where the older units had a limited remaining life. So this is the manner in which the Commission has mitigated in the past, and is what we have looked at as our example for the mitigation for today. We hope that the Commission will continue to apply mitigation in this fashion and will adopt its staff recommendation. I'll reserve the balance of my time for rebuttal.
Thank you very much. Oh, I got a lot of speakers. Mr. Sherman, I'm sorry. Commissioner Groom has a question.
Certainly.
For you.
Mr. Sherman, you're talking about taking this mitigation fees and you would cover a bunch of new units. I mean, do you have any idea of where the units might be and when they might be built? I mean, would you and your client be willing to participate in that so that we could expedite this if we should approve this?
I don't know what form the participation would take.
I think we all have to be working together to find a location and to be able to get it built just as quickly as in order to get those units up and running.
Well, we have had, there is one proposal for the Santa Monica Hostel to in fact build some regular rooms as an adjunct to the hospital and are in need of funds to do it. There were 26 rooms associated with that. I don't recall what the dollar amount was. There is the motel in Topanga, and I should say the Santa Monica Hostel is half a block away from where the Shore Hotel is. We would be happy to participate in trying to facilitate those things. I don't know that we're the actor that is best suited to doing that. But certainly if there were a condition fashioned requiring that we participate in assisting the Commission staff in the allocation of the funds, in locating and proposing use of the funds under Special Condition 7, we would do whatever it was we could do to assist the staff. We had other proposals, expanding campgrounds on Catalina Island that are utilized by youth groups, campgrounds and facilities in the Santa Monica Mountains. There were several things that we had gone through. In the end, the staff decided, and I should say, we had intended to come, we wanted to come with actual proposals. But the staff decided it was too complex and difficult. I shouldn't say that. I'll let the staff say why they decided that the mitigation fee in money was the preferable method, and we agreed with it.
I appreciate your answer, but for me, the solution here is to have another travel lodge built just as quickly as possible. Not a hostel, not campsites, but another travel lodge. That would be the best solution, is in my view. But thank you very much for answering my questions.
Thank you. All right, I've got a bunch of speaker slips, a bunch. So, I beg you all, I mean, you've stayed here all day and you're entitled to speak. But those of you who have already spoken in support or against, I would suggest that you just allow the other people who haven't spoken. So I will call names. These are people who are in support. Angelica, what is that? Can you read that? Angelica, are you out there? Okay. Carlos Corletto. All right. Molly Basler spoke earlier. Dulcie Doherty. Elizabeth. Can you read that? Guerrero. Scott Wagonseller spoke earlier. Is he okay? Okay. So now I'll go on to the opposition. Anna Evans Goldstein from United Here. Now again, you have a number of people, all from United Here, which again, if you want to speak, you can speak. But I'm sure you have a kind of united point of view as well as...
There are a couple of people that have decided to not speak, but
That'd be
most of
lovely.
us are still coming up here.
All right.
We will go as fast as
I'm gonna
possible.
I'm going to give, you have 2 slips, so I'll give you 4 minutes, and everyone else will get 2.
Okay, Chair Bochco, Commissioners, thank you for still being here. My name is Anna Evans Goldstein, and on behalf of the 30,000 hotel workers that Unite Here Local 11 represents in Southern California and Phoenix, Arizona, I am here to urge you to deny the Shore Hotel a coastal development permit. The findings by Commission staff cannot, in fact, be made. The standard of review for a CDP is that the project must comply with Chapter 3 of the Coastal Act, which the facts as presented in the application do not do. The City of Santa Monica's certified land use plan portion of its local coastal program requires on-site replacement or a one-to-one replacement in the coastal zone. Only if neither of these alternatives is feasible will an in lieu payment be made. It is simply not true that on-site replacement or one-to-one replacement in the coastal zone is not feasible. We already know that low-cost accommodations at this site is possible because it was originally presented and approved to be low to moderately priced accommodations. As staff notes in their report, an after-the-fact CDP must be reviewed as though the unpermitted development has not already taken place. But no amount of money could mitigate the fact that the demolition 10 years ago of the original facilities where the Shore Hotel now stands accounts for 35% of all low to moderate cost visitor accommodations lost between 1992 and 2018 in the city of Santa Monica. 35%. This is a drastic loss, one that should never have happened. According to the City of Santa Monica Ordinance 1516, there must be a correlation between the in lieu fee collected and the type of development for which the fee is charged. The way the in lieu fee is comprised here, there is absolutely no assurance, an urging, sure, but no assurance that it will be used to create new low-cost motel rooms in the coastal zone, let alone in the City of Santa Monica. These funds might be used to create other forms of accommodation, such as campgrounds or hostels. This raises a concern about polarization, as replacing low-cost motel rooms with campgrounds or hostels may still preclude some people from being able to enjoy the coast. While some visitors requiring low-cost accommodations may find campgrounds or hostels suitable, there are certainly others who would choose not to stay in such an environment, preventing them from enjoying the coast. For those people, the loss of 72 low-cost motel rooms in Santa Monica is a huge tragedy, and one that deepens the inequality present in coastal access and overnight stay. This project gets at the heart of why we must be strict when protecting access to the coast, and why development must be heavily regulated. Staff notes that 70% of all rooms lost since 1989 have been lower cost. They acknowledge that new development tends to replace low-cost accommodations due to the economic incentive for developers to replace these facilities with higher-cost ones. The CDP before you makes a mockery of this commission and the protections of the Coastal Act, and I urge you to deny the CDP for the Shore Hotel today. Thank you.
Thank you. Maria Cortez, followed by Edith Garcia, followed by Keisha Woods. Who's that? Okay, come on ahead. Oh, there you are.
I'm the translator.
Oh, thank you. Thank you. Just have her state her name.
¿Puede decir su nombre?
Sí. Buenas noches, mi nombre es Edith García
Okay.
y trabajo para el Hotel Loves de Santa Mónica por 30 años.
My name is Edith Garcia. I work at the Lowe's Hotel for 30 years.
Yo también vivo cerca de la costa
I also live close to the coast,
y me preocupa qué tan costoso se está poniendo.
and I'm worried that cost of living is becoming very expensive.
Cuando empecé a trabajar en Santa Mónica, todavía podía darme el lujo de llevar a mi familia a pasear.
When I first moved to Santa Monica, at the time, I did have the luxury to be able to travel with my family.
Y eso se está poniendo cada día más difícil.
And the ability to do that every day is becoming more difficult.
Es muy importante proteger a los hoteles de bajo costo
It's ve- sorry.
que están en la costa.
It is very important to protect low-cost hotels, especially when they're close to the coast.
Particularmente en Santa Mónica, donde hoy existen muy pocos.
Especially in Santa Monica, where there are very few now.
Trabajando en Santa Mónica he visto los cambios con el paso del tiempo
Because I've worked in Santa Monica, I've seen how the city has changed over time.
y quiero pedirles que pongan un ejemplo en proteger la habilidad de todos en poder visitar la costa.
And I want this governmental body to make an example of how we're supposed to protect the ability for everyone to visit coastal cities.
Un negocio que mintió en proveer cuartos a bajo costo solo para crear una experiencia lujosa no debería de seguir operando en Santa Mónica.
A business that lied in saying that they would provide low-cost hotel rooms and instead created a luxury experience should not be allowed to operate in Santa Monica.
Por favor, no les concedan el permiso. Gracias.
Please do not give them the permits. Thank you.
Thank you. Edith Garcia, followed by Keisha Woods. Please. Come on up. That was who? Oh, well, what happened to Maria?
This is Maria.
Oh, this is Maria. Okay, sorry, got you too confused.
Buenas tardes, mi nombre es María Cortés. Trabajo en el Doubletree, soy recamarera por 20 años.
Good afternoon. My name is Maria Cortez. I work at the Doubletree in Santa Monica as a room attendant for 22 years.
Estoy aquí para hablar con ustedes y animarles que no les concedan los permisos de desarrollo.
I'm here today to talk to you, to encourage you and to not concede giving the permits of development, the coastal development to the
Al Hotel Shore.
to the Hotel Shore.
No es justo que el Hotel Shore esté operando por casi 10 años y mi hotel donde yo trabajo ha seguido obedeciendo las leyes.
I don't think it's just that the Shore Hotel has been operating for in this way for 10 years, while my hotel where I work at has continued to obey the laws.
No pienso que es justo en permitirle al Hotel Shore que venga ahora después de tanto tiempo.
I don't think it's fair to permit the Shore Hotel to come now after so many years.
Y finalmente le concedan permisos a ellos. Por favor, no les den el permiso.
So after so many years and come here and finally be allowed to get this permit, please do not give them the permits.
Thank you.
Thank you. Keisha Wood, Jonah Breslau. Will be followed by Charles Dew.
Hi, my name is Jonah Breslau, and I was a bellman at Shore Hotel for about a year and a half from August 2014 to around February 2016. And I spoke before this body in 2015 and again in 2017. And while I was here in 2015, I was speaking about several violations that I personally witnessed while working at Shore Hotel when it became apparent that the hotel was operating illegally. And I testified at the time, that while working there, I was, trained to create a 4-star experience for the guests. And I personally helped prepare and deliver room service at the on-site kitchen for guests, even though no permission had been granted for that kind of service. So when the commission denied the Shore Hotel and after the fact CDP in 2015, I felt as though some degree of justice had been served. Because my coworkers and my testimony helped to bring those particular violations to light, I felt like I had done my civic duty in coming before you all, despite the potential risk. And I want to continue to have faith that the government will do its job and enforce the law in this matter. And I'm frankly amazed that I'm still speaking to the violations perpetrated by Shore Hotel in Santa Monica. And so I'm here today again to speak about this issue and ask, how has this not been resolved? How does the Shore continue to operate as a luxury hotel? And how is Sunshine Enterprises allowed to still operate the hotel despite ignoring the law? And now all they have to do is pay a large sum of money and get the CDP that they should have worked to receive years ago? I'm concerned that other developers and hotels viewing the long saga of Shore Hotel will see an opportunity to skirt the law, make lots of money, and pay a fine in order to continue operating. Please do the right thing and deny Shore Hotel their CDP.
Thank you. Charles, are you coming up? Charles Dew, thank you. And be followed by Bill Pritzlucky.
Hi, my name is Charles Dew, and I'm a staff attorney for Unite Here Local 11. Earlier, applicants' representative attempted to argue that one of the reasons they couldn't pay the $15 million penalty in full now was that they were reserving part of their available cash to pay the mitigation fee associated with this permit. This kind of linkage is inappropriate, and I'd like to emphasize that the Commission's decision right now regarding the CDP is an entirely separate matter from the enforcement item we just heard. But anyhow, there's no amount of money that this applicant could pay that would result in a one-for-one replacement of the accommodations that have been permanently lost here. Under current law and standards for fee calculation, there's no way to adequately disincentivize developers from shenanigans like this by imposing fees and fines alone. We know that land values along the coast are exploding, rising higher than the consumer price index and the cost of construction alone. And there's only so much prime coastline. You can't create new coastline with mitigation fees. The only acceptable alternative would be to require that the Shore Hotel turn 87 of its units into affordable accommodations, as Commissioner Peskin and others have suggested. Of course, the applicant would be very reluctant to agree to this, because if there's one thing you can trust, it's that they want to make as much money as possible. The applicant has repeatedly failed to follow through on its commitments, so even if they did agree to 87 affordable units, you could never trust that these units would actually materialize. Sunshine Enterprises is simply not trustworthy. The only real solution here is to deny the permit and to leave this matter to a different owner-operator that can be trusted to do this correctly. Closure is a serious remedy, but it's more than appropriate in this case. The Shore Hotel should cease operations now. We work with a training academy that specializes in placing displaced workers into hospitality jobs with security and benefits, which could help Shore Hotel workers find other jobs quickly. Thank you.
Thank you. Bill Pritzlucky? He had to go home. Okay. Does the person, Charlie Carnow, who is ceding time, want to speak? No. Okay. Sharon Fudge?
Thank you, Commissioners, for allowing me to speak on both the penalty phase of this and the consideration of a new CDP. I'd like to propose something to you that in 2009, CDP 5-09040 was approved for a 164-room low to moderate cost hotel. That is what we've lost. We've lost 164 rooms that were supposed to be low cost, not 72. We were promised, we were handed, and made all of the arrangements for 164 rooms. The fact that the applicant has chosen to make those a luxury accommodation, I believe should not have anything to do with your decision on how to approve this project. If you do approve the permit, I would also ask that the conditions be more carefully looked at, because they're very hard to enforce, and especially when you have an applicant who has shown that they are reluctant to do so. And I'm going to just go through a couple of those in the Transportation Demand Management Program, and just kind of dive in a little bit on a couple of the conditions. One is condition 6, lowercase 9, which is if guests condition 6.4, free bus tokens are going to be given to guests upon request. Well, there's nothing in the conditions that say how that's going to be monitored. How are the guests supposed to know that they need to request these bus tokens? If guests are directed to use off-site parking, which is in violation of, it's prohibited by the condition, what happens? So I ask, if you do approve the permit, that the conditions have some enforcement behind them and that it's more neatly wrapped up. Thank you for your consideration.
Susan Jordan?
Susan Jordan, Director of the California Coastal Protection Network. At the end of my testimony this morning, I urged you to really think twice about approving any CDP that in any way rewards the violator for his behavior. And that's where I'm having a real problem. They were not supposed to have a restaurant. They illegally operated one all this time. But suddenly, you look at this application, and they have 2 more restaurants in there for a total of 3. To me, that rewards the violator. They are getting an additional benefit. And if you look at your mitigation fee and you subtract the city of Santa Monica and then you subtract the value of those 2 restaurants, I don't actually think you're getting a very big mitigation fee. So those are the kind of things I think you have to really think carefully about, because I don't think any additional benefits should be accrued to a violator. Thank you.
Thank you. Donna Malamud is our last speaker card that I have.
Hello, Commissioners. My name is Donna Melmood, and I'm a community member. I'm a volunteer at the Santa Monica YMCA as a volunteer exercise teacher, and I know we can do better. I urge the Commission to deny the Shore Hotel as CDP. The hotel has, over the past 10 years, misled the public, ignored the law. The Sunshine Enterprises has deprived the city of Santa Monica crucial lower-cost accommodations, as everybody has said here. The city is in desperate need of. My own relatives, when they come to visit, they can't find any place affordable to stay if they can't stay with us. It sends the wrong message to any other potential developers or business owners operating in the coastal zone to grant them permission to continue operating now. At every step of the way, the applicant has done the wrong thing, misled you, the Commission, on the intentions of their project, illegally operated a luxury hotel with full-service amenities, and appealed every decision that has ruled that they have been at fault. We are only here now because they have no other recourse but to pay the money and apply for another permit. They cannot be allowed to operate in Santa Monica. Are they trustworthy? Why wouldn't they just continue to disobey the law? even with a coastal development permit. They have proven themselves to be devious business owners, and none of us should believe that they will comply with the law. I plead with you to not approve the coastal development permit application for the Shore Hotel. Thank you very much.
Thank you. Okay, that's our last speaker. Mr. Stacy, would you like to? You have 9 minutes for your rebuttal.
The uniform argument is that you should deny the permit. When we make an application for a permit, we deal with your staff. We work with them as your representatives, although you have the final decision, to try to reach what they believe is a proposal that will comply with Chapter 3 of the Coastal Act. We have done that, and they have made a recommendation. I believe that the conditions, your enforcement section is far more attentive than it had been in the past, and the Shore Hotel is deeply chastised by the losses they will have already suffered, and wishes to operate in the future in accordance with its conditions. I can see that there is distrust, but I am asking for the opportunity to go forward in accordance with conditions that meet the provisions of Chapter 3. There's nothing in Chapter 3 or in the Coastal Act that says because people believe and wish to convict someone in this proceeding of bad acts, that you must further punish them by depriving them of whatever you would act for another party. We have agreed to the penalty and are paying the penalty, and at some point we need to be able to feel that we are able to be treated as equally with others. Now, at the end of today, we are perfectly willing to take direction from the Commission to your staff if this is not a recommendation that you are going to approve. We worked to reach this recommendation in the expectation that it would be well received. That, I think, both on your staff's part and on our part, was an honest belief. If it is not to be well received, I think your staff could use direction for what your expectations are, and that we could work to see that we could meet those expectations. What we worked with your staff was to meet the expectations established by the prior precedents of this Commission in prior actions that you had had. Hotels down the street approved with minor mitigation fees many years ago. I realize things have changed. Hotels that don't displace lower cost facilities not having any mitigation fee imposed. They are other hotels in Santa Monica that have been built, and I realize they're built under coastal permits in a different era, but they do not have the same limitations that you impose today and that we are willing to do today. So I'm looking for the Commission to perhaps help their staff by letting them know where we should go. The findings you had made in 2015 did not give a particularly good direction, and what we understood from them, and I believe your staff understood, was that the mitigation fee was far too low and it needed to be based upon some standard for reproducing motels, not simply hostel beds. And that's what we came back, and that's what we worked with your staff to accomplish. It's been an honest effort to do that, and an effort with the commitment financially behind it to perform. It's difficult to get up here after people tell you that you have no place in their community. I could spend time, and perhaps I should, because the Shore Hotel also does good things in the community. They provide an excellent service. They are a participant in generating revenue for the city. They run a good business. But I don't know that that's what you are really caring to hear about. They truly want to make amends for whatever they have done. The penalty, we believed, was the amends, and if there are further things we're going to need to do, I would ask that in your action today, you either adopt the staff recommendation or give the staff some direction. We are only a couple of months since the filing of the permit application, and we have time to try to work with the staff before the time limit for commission action runs out to see if there are things that we can do that would be acceptable to the commission. We have done what's acceptable to the staff, and that's who represents you to the public as to what to do. I know you don't adopt every staff recommendation. You have disagreements with the staff, but I do believe that the staff has honestly operated based upon Commission's prior actions, and that we are seeing a shift partially motivated by the unique facts here, but a shift in what the Commission's expectations are. In that regard, I want to at least relate something that I think in terms of what we consider mitigation. What I'm hearing is that what should be is the replacement, that a person who has a property that has a hotel on it that is older must replace what is there rather than mitigate the impacts of its removal. And I'm not certain that that's ever been how we have understood mitigation in the past. And the cost to replace, and when I say replace, that means you pay the entire cost to replace, and the sums of money that you pay as mitigation pay only a portion. I represented American Youth Hostels as a pro bono client years ago to build that youth hostel around the corner. We collected money from fees the Commission had taken in Marina del Rey and other locations. We got private financing, and the mitigation fees didn't pay for the whole thing. They paid for a portion of it because every one of these businesses, when finished, has a cash flow, has a income, and has the ability to pay for some of their capital improvements. So I would end with asking again for you to adopt the staff recommendation, and short of doing that, express yourself to your staff of what you expect them to have us do, because we have exhausted with the staff what we thought would achieve the approval of a permit. And we're ready, if it's not to be, to go back to the table with them to try to do so.
Thank you. Thank you very much. Okay, so I'm going to bring it back to staff and tell me
Thank you, Madam Chair.
your
Just
thoughts.
a few observations. This has been a really difficult permit application we've been dealing with many, many years. And I just want to note, when we look at a permit application, We look at it without bias, whether or not an applicant's a good actor or a bad actor. We look at it for consistency with the Coastal Act, the project, for consistency with the Coastal Act. You're not the first commission who has struggled with this issue with regard to how do you mitigate for the loss of low-cost hotel rooms, or how do you, or for not providing low-cost rooms within a hotel. And this is, for as long as I've been here, this has been a challenge. And one of the reasons is the Coastal Act prohibits us from setting a room rate, so it makes it really difficult to mitigate on-site. And that has been a problem that we've dealt with. So the commission came up and has been utilizing an in lieu fee for many, many years. And several years ago, when we were preparing for the low-cost overnight accommodation workshop, we took another look at how we were assessing those fees. And we hired an economist who helped us determine what is the cost to build an actual hotel room. And it came out to be $100,000. And that's pretty much using that Turner Index, that's what it is today. It's like $52 more. We also were working with state parks at the time, and they determined that it cost about $100,000 to build a cabin that comes fully equipped, somewhat equivalent to a hotel room, or as close as we could get. So that's what we were recommending in that originally in our low-cost overnight accommodation workshop. The commission didn't accept that. So we have been ever since looking for that opportunity to take another look at that. And when this came along, it really comes down to the fact of what does it take to actually replace a hotel room, equivalent number of rooms. And we came up with this mitigation figure. Is it perfect? No. You know, if we look at, we're looking to put this money into into two places. One could be the hostel, the Santa Monica hostel. That's a shovel-ready project. It's ready to go. They need about 26 rooms, I think 26 rooms. And these are private rooms. These are more akin to a hotel room. And the Topanga Ranch Motel, which is an opportunity to, they have about 30 units there. We're also looking at the potential of some additional cabins that could be built there as well. And those costs for that motel complete, and I've been working with state parks on this, comes out to about $16 million. And the reason for that is not just because it's a historic hotel, they got to bring it back up to these historic standards using historic architectural requirements. The other thing is that it doesn't have, it has to have a brand new package treatment plant, a sewage treatment plant. So those costs increase. So that's what makes it more difficult in this case to develop that. Now we could use some other funding to help realize that project, but that is the vision, what we have for this money. Not only the mitigation fee, but also for the monies from the fines to help us realize an actual project within a reasonable time frame, and that's what we've been trying to do here. And I'm a pragmatist. I try to work a problem solver, and that's what I directed our staff to do here, and that's what we've been trying to achieve. And so, if we've missed the mark, but that's going to be up to you to determine. And we leave it to your good judgment. We'd like some direction if you have some other ideas, as Mr. Stacy said, because we need creative minds to deal with this really difficult project. So I turn it back to you, Madam Chair.
Thank you, Jack. I actually, just before I turn it over to Commissioner Peskin, who has some thoughts, I just want to make a little pitch for the Topanga Hotel, Motel. It's very dear to my heart. I used to live just up the street from there, and it's one of the most charming and beautiful spots. It's not right on the beach, it's across the highway, but it could be such an incredible place for people to go, because they are like cabins and stuff, which is, it's so rare you see. It's like, it would be like Crystal Cove if it wasn't quite on the sand. So anyway, I'm just pitching that, but Commissioner Peskin?
Thank you, Chair Bochco. So I have a few questions and then some kind of overarching policy thoughts that maybe the 11 of us want to explore. My first question is, relative to the $1.2 million that Santa Monica received, do we know what they did with that money?
I don't believe any of those funds have been spent yet.
Is your microphone on?
Yeah, yes. Can you hear me?
Yeah.
I don't believe that any of those funds have been spent yet. They were waiting for some kind of commission approval.
And so potentially that 1.2 could be used in conjunction with whether it's a Santa Monica hostel or Topanga motel or unidentified third sites.
I think that because it's already in the hands of the city of Santa Monica, it would only be applied to projects in Santa Monica.
That's right.
That makes sense.
Yeah.
But do we know if they have identified or sought to identify projects? Do they have other sources of money, or all they have is that 1.2?
I don't think they have anything else.
Yeah, we don't have any information that they do have an identified project for that money.
I mean, the logical project, of course, is the Santa Monica hostel.
Has there been any communication between coastal staff and the city of Santa Monica as to their interest, if at all, as it relates to the hostel project in Santa Monica?
Do you guys have any contacts with that?
No, I think that the city, we've discussed the 1.2 million, of course, with the city and these different projects, but the city really, I think, is holding in a holding pattern on this. They have not allocated this money to any project.
Okay, and then this is a question for the project sponsor. I thought I heard earlier a indication that the applicant owns other properties and maybe other motels. I don't know where they are, but I remember hearing that. Is that true, untrue? Are they in Santa Monica? Are they in the coastal zone?
There is a hotel down the street that the commission approved some years ago, on which they paid a mitigation fee for the demolition of the auto-tel that had been there previously. And there is a motel within the coastal zone on Lincoln Boulevard, south of Pico. You're not all familiar with Santa
Yeah, I'm a
Monica, but
Northern Californian.
That's about 6-7 blocks from the shoreline.
Okay, but within the
coastal zone.
Okay, thank you. I appreciate. And do either of those properties, as to the first one, is there any opportunity there for expansion within current zoning pursuant to the LCP?
Well, as you know, the Santa Monica is coming in with a new LCP. They, I think, may have made some changes to the height limitations, but the difficulty is that you end up doing subterranean parking for these, and you can't dig deeper under an existing building very easily if you're going to expand the number of spaces that you need by adding floors.
But if parking was not an issue for whatever reasons, TDM, proximity to public transit?
I can't attest to the structural nature of how they were built, that they could in fact be expanded with additional floors. I can inquire.
It would be an interesting factoid as to the two properties that are in Santa Monica in the coastal zone. But yeah, I mean, if you want to do a little bit of research, it would be interesting. So, Madam Chair, colleagues, I know that staff looks to prior precedent, and so that's what's informed their discussions around what they've recommended. But I think we can distinguish this as rather unique. I forget who said it, but we view this as variously the loss of the formerly more affordable visitor serving accommodations, or the calculation of 25% of 164, or as one member of the public said, actually we should view it as the original representation that 100% of the units were going to be affordable. But I think this project is distinguishable from other projects because of its long and tortured history, and I'm completely aware that in the previous item that we have settled, we dealt with the fine, and I'm appreciative of the change in the timing. But I really think not only as to this case, which we can distinguish, but as to what we all know is the phenomenon of the massive loss of more affordable visitor accommodations, of which this is actually a not insignificant part, that we might want to consider using this as a place where the commission really changes its policy. In the old days in San Francisco around issues of affordable housing, it was, somebody gave an impact fee to the city, and then the city would do what's almost impossible in San Francisco, which was try to find land and build 100% affordable housing. Later on, it became, you could have an option between on-site affordable, off-site, where you could go and get another piece of land and build that affordable housing component off-site, or pay an in lieu. So I think we should be having a conversation about those things as a policy. I mean, as I said earlier, and I was not being glib, I don't think we want the money. We want the units. And to the extent that, and by the way, let's be real, which is when State Parks does this, it takes longer and ends up costing more than when a private party does it. That's just reality. So to the extent that you can get, in the case of San Francisco's luxury housing developers, to incorporate those below market rate units in the project on site, or they go and buy a piece of land. And by the way, we do this in our housing scheme within a proximity of a mile from the project if you're going to do it off-site. So it's not like, you're building in the well-to-do part of town and you put the off-site housing in the poor part of town. We make it's got to be within a mile of the project. But I think we should have a conversation about and give staff that direction and give the applicant that direction, that what we're really looking for is on-site, which could mean the current Shore Hotel, maybe it gets redesigned and a portion of it is the affordable portion, a portion is the luxury portion. Maybe it's off-site, which could include a myriad of different options, but they're real options. And I was actually very pleased to hear that some 50, between the 30 potential units at Topanga and the 26 at the hostel, that there has been some real exploration of things that are, I'd say, reasonably proximate, but that still leaves a bunch of units wanting. So maybe it's an off-site option. They've got two pieces of property that can be looked at. But I would say that the in lieu fee is my least, and I think our least attractive option. I mean, here we know Santa Monica's been sitting on $1.2 million. They don't know what to do with it, and that often becomes the case. So those are the thoughts that I wanted us all to think about. And with that, I will relinquish the microphone.
Vice Chair Padilla.
Thank you very much, Madam Chair, and to echo much of what my esteemed colleague, Mr. Peskin, said, I think after taking the testimony and reviewing the record and the staff recommendations, I think it's difficult for me to support findings at this stage without refinement that really address some near-term, real, one-for-one or blend of on-site mitigation with fee. I think what I struggle with in this application is the fact that when you boil it all down, the net impact of the recommendation, as diligently as it has been worked up, is the status quo plus a mitigation fee. And there's been a lot of dialogue about where some of the optimal locations and specific projects that would be appropriate to receive the benefit of those fees and achieve some mitigation. There was extensive comment from staff about that, combined with a reference to the prior enforcement matter and some of the additional benefits there. But looking at this application on its own, we have to get there independently of the enforcement matter. We have to look at the standard and make findings as to whether this mitigation is adequate to make it consistent. And this is a unique situation that does stick out, and I have to be candid. To be frank, I think we need to get to a better level of short-term specific on-site mitigation in this particular case because of the history and facts in this case, or I can't support those findings, and I would not be supporting the recommendation. And again, being candid, I don't think the comments from the applicant's rep were helpful. In fact, I'm disturbed by it. Even after everything, even after the report and the review and the testimony, being sure that we are having adequacy around mitigation in these circumstances is not punishment, it's protection. Asserting that this is a result of people not wanting a place in their community for this developer or the development is not helpful, and in fact is a little offensive. They're correct in that the circumstances here are unique. You bet they're unique. I've served, this is my second tour of duty on this commission. I've seen and heard and sat for a lot of permit applications in my career. This one's kind of unique. It's unique in the degree to which this is an after the fact application. And it is something that, quite frankly, is a result of decisions that were willful disregard of prior permits. And that brought us to this place. And I think when you just put all that together, I think we have to look at some additional components for restoration. Maybe that's in combination with in lieu fees. Maybe there needs to be additional specificity around a commitment to helping to identify some specific facility program in a greater level of specificity. I don't know what that is, but I think we have a little more work to do before I can vote to support findings and the recommendation as it is. I'm certainly willing to try to get there, but if we can't get there, I can't support these findings or the staff recommendation.
Commissioner Vargas.
Thank you, Madam Chair. I'll be quick. First, to address there was some kind of intimation that we weren't approaching this with, or that we were approaching this with bias. And as our executive director mentioned, we're approaching this not with that bias in mind, in a rational manner, as we would any other project. There is a difference with this project, though. As has been mentioned by other speakers, this is an after-the-fact permit, which is not a normal application process. We can't view this from the lens that the applicant is waiting to build something new that hasn't happened already. We're doing this from the lens that they've done something that they weren't supposed to do, and we now have to react to it. So that is just a matter of fact. I want to go on record saying that I think Commissioner Peskin is absolutely right. Just as we've kind of struggled over the past few years with issues like climate change, sea level rise, and shoreline armoring, and have gotten to the point now where we realize we've reached a point of no return where we have to be aggressive about these things. We've reached that point of no return when it comes to the loss of low-cost accommodations. And it's time to get real about that. And we know over the past few years, we've seen this with our own eyes that, in lieu fees just aren't cutting it. We've done analyses that show that in lieu fees sit in pots of money in different cities, counties, and agencies and don't get deployed because there's just not enough money to make them happen. So I really think Commissioner Peskin's reorienting and making a paradigm shift here into having conversations from now on with applicants about like-for-like restoration or mitigation in a close proximity of the area that's being impacted is what we should really be aggressively focusing on now. Only with a very rare exception should we be looking at mitigation fees. And with that being said, to this particular application, I also can't support this in the way that it's written. Using what I've previously commented, I think the perfect location for these low-cost accommodation units is right on site. Thankfully, the applicant went ahead and built beautiful units, and those would be perfect as low-cost accommodations. I don't know why we have to look anywhere else for those. I think we should at least look at the number that were taken away from the people of California as a baseline of what we should be replacing. If we want to, at the very least, all of the 3 restaurants that they're asking for that were never approved and never contemplated 10 years ago, the square footage of those 3 restaurants combined would make about 20 units of what their smallest hotel room is in the Shore right now. So I can't sympathize with an argument that would tell me there's no room to build these. I certainly can't sympathize with an argument that says that we can't afford it, because you already built it and you took it from us, the people of California. So we want it back. If I'm not making myself clear, I want to see a solution and an application that moves forward only with units, low-cost accommodation units that are on site or very, very near, and that the applicant is on the hook for it. Thank you.
Thank you. Commissioner Levino.
Well, thank you, Madam Chair. My colleague, Commissioner Vargas, just stole my thunder. So I will not repeat everything that he said, but just agree with all of my colleagues, actually, but in particular with what Commissioner Vargas said with regard to an on-site solution to this problem. And I just want, and with regard to, you know, the comment that this, by Commissioner Padilla, this is the status quo plus a mitigation fee. We forgot to mention that there are 2 new restaurants in addition to this. So, and as somebody who's grown up in this area, who's used Santa Monica Beach since I was a child, this is, you know, the pier is one of the most popular, if not the most popular destination in the world. So proximity to the pier is vital. And while there are some alternatives we've mentioned, all of them come at some sort of deficit. And I'm just not able to wrap my head around any of them, frankly. So with that, I will conclude.
Okay, Commissioner Ranga.
Thank you, Chair Bosco. I'll be blunt, be straightforward. Burn me once, shame on you. Burn me twice, shame on me. I'm not going to be burned again. This happened to me when we did the retaining wall in Laguna Beach. I voted for an after-the-fact wall, and then they came back and did a redevelopment, a remodel. So I'm not voting for this.
Okay. Commissioner Groom.
Thanks, Madam Chair. You know, it's been said several times that the standard operating is to do mitigation here and mitigation here. This is not standard operating. We're here today with this dilemma because this applicant violated our rules. They went and did something they shouldn't have been doing without a permit. That's why we're here, not because this is just a routine run-of-the-mill. So I think the standards are different.
Okay, I think what we need, well, just before Commissioner Howell, because I will definitely call on you next. I think what we need here, though, from the commission is some instruction for staff, what you would like to see. And Commissioner Vargas was clear that he would like to see low cost on-site. I think you should also speak to the fact that they do have another facility close by that may or may not accommodate this. But just give them some direction. I don't want to just send them back without anything. So, Commissioner Howell.
Yes, exactly. That was somewhat the point I was trying to make, Chair Boschko. On one hand, we want to give direction to staff, but this is a very unique situation, I think, and it has a unique history. The fact that these were low cost, well, whatever. Everyone knows the history. But the point being is I want to make certain that staff doesn't overlearn the lesson on this. I think that we do need to think outside the box, as Commissioner Vargas mentioned. Is we don't want to be closing the door after the horses left the barn, and it's mostly out of the barn already on low-cost accommodations. And I think we should be looking into things like sort of conservation easements on our Ma and Pa hotels. That's one way that we can do protections of our low-cost accommodations going forward, and that's a way going forward that hotels can mitigate.
I think, by protecting and sticking in conservation easements these hotels at the rates that they're at right now. I also have some concerns too, and I know you don't want to hear about this, but we've got a project coming up in Avila where we require some kind of strange things, like 240 days out of the year it's going to be low-cost accommodations, and then the rest of the time it's not. I think that's really a bad model. And just because you're bringing in high-cost accommodations, if it's a new project, doesn't mean that you have to mitigate for some of the mistakes that we've made previously in not protecting our low-cost accommodations. So I mean, I certainly can't support the staff recommendation today, but I hope going forward that the staff doesn't overlearn the lessons and comments that we're getting from the commission staff on this very specific project.
Commissioner Peskin.
So, Madam Chair, let me see if I can summarize direction to staff and the applicant, and then perhaps, insofar as we've opened the hearing, maybe we can send this back to staff and have it scheduled at a future meeting after more exploration is done around this. I think choice number one is on-site, and that's going to require some very serious looks at, design and redesign, and may or may not be feasible. And some of the concerns that staff expressed as to why that was thought about and ultimately not recommended need to be considered, but there may be ways to deal with that. Second option is off-site within a reasonable distance, which I would say is no further north than Topanga and no further south than however many miles Topanga is to the north, but within, so say again? She says Venice. And that there be a off-site option, and it may well be a combination of three things, i.e. Topanga, the hostel, and a yet-to-be-identified future draft pick. The thing that we do in San Francisco is we actually say, you don't get your certificate of occupancy for your luxury condo building until you have the affordable below market rate, this is housing, not transient housing, but until those are ready. So we don't give you your certificate of occupancy for your market rate $1,200 square foot condo until you are ready to open the doors for the below market rate. I think we should, you might want to explore that. I think that summarizes everything. I don't think we should preclude off-site. I think we should emphasize on-site, and I think it is the sentiment of this commission that a fee out is the least attractive alternative.
We need a motion for continuance if that's what
if that is acceptable to my colleagues and to staff, I would make a motion to continue this to a date that staff recommends.
Second.
Okay. Any more conversation? All right, we have a motion on the table for continuance. Do we need a roll call vote? Are we in agreement? Okay. So we unanimously approve a continuance.
Thank you, Madam Chair. That gives us some good direction, and we'll be working closely with the applicant and see if we can get something back to you just as soon as possible.
Great, thank you. Okay, all right, where are we now, kids? I can't believe it.